Hi.
Hi everyone. How are you, Sarah?
Good.
I joined so late I didn't even get to say hi to you behind the scenes.
No worries. How's your week?
Good. I love your hair.
Oh, thanks. Yeah, it's still wet from yesterday.
Really?
Yeah,
It's
I had
so
it in a
long.
braid. I had it in a braid, and then I thought it would like come out and it would be all curly, and it's still damp.
Oh no.
So I have a lot of hair. I kind of want to cut it,
It looks good.
but I'll miss it. Let's see. So let's see. Okay. I feel like a lot has happened, but also kind of not. I don't know.
Yeah. A little bit of a recapping all the dockets, going through as I'm going through it again, I'm just sometimes I get worked up all on my own and I come up with new theories, and I want to
Right.
come on live and I want to come talk, but then I just think I need to get this timeline out before rulings or before, just to give people some time, but it's just so much.
Yeah.
But I've been wanting to do this for some time, so thank you so much for having me.
Yeah, I was like, because I noticed when I went live the other night, because I normally get like 10 people, and then I was like, why are there 54 people? And then I remember I was like, oh yeah, right, Bachi's on vacation.
Yeah, I've been getting messages about people having bocce withdrawals.
I know, and I'm like, oh right. So let's give the people what they want. Um, so yeah, I mean, I think the biggest things are the settlement conference and then
Yeah.
the New York Times article.
Yeah. Which one do you want to start
Let's
chatting
say,
about
I
first?
guess let's do the settlement conference because I think the settlement conference might influence the New York
Uh,
Times article a little bit.
I've thought about this a lot, and I did like that they brought up like Judge Lyman's other ruling. And then when we think about you've been talking about this for some time about how the Andy Cohen. I don't remember what the other
Oh,
name.
McSweeney.
Sweeney,
Yeah.
yeah, the McSweeney case. And after the settlement conference, I've been thinking about it a lot, and I just don't see how the judge allows the SH claims to go forward for at least Baldoni. Um,
Mm.
so, but I have a little bit more thoughts on that, but I'll let you kick it off the way you'd like.
Well, yeah, and I even kind of because like I feel like a million years ago. Let me pull it up. Let's see. Do I know how to pull this up? There we go. I was looking at this because years like a year ago, not really, a couple months ago, I had done this document, right? And I went through and I was like highlighting and deleting causes of action and all this. And then I
Yes.
kind of let me see if I have the one I did yesterday. Let's see what I think will happen. Oh, maybe I don't have that one. It's this one. Yeah, okay. So, I mean, I kind of went through because I've now had a chance to read the oral argument. And I was like, this could be if Lyman is kind of starting to look like let's try and keep things in because he doesn't necessarily want all of her case to go away at the law level, right? I mean, or at least I don't think he's excited to do that. But I mean, I was just looking at like the oral arguments and it's like now I'm starting to think a lot more is just going to get dismissed. He might let the 17-point agreement go and he might but I don't know.
What do you mean let it go?
Like let it go to a jury as a separate contract. But I think the
It
problem
doesn't
is,
have consideration.
well, they're saying the consideration is waiving the HR complaint.
But we're here because of the HR complaint. And I think the judge even pointed that out. Like, how could you waive something that you're now enforcing?
Yeah, I mean, I'd say in her response to the motion for summary judgment, she
Mm-hmm.
says that the retaliation, she's trying to like link the retaliation to the sexual harassment to try and say that like, yeah, I did waive it, but then you guys kept doing stuff. So I had to like you guys breached it first.
Yeah, I just the problem with that is none of the stuff is after the 17-point side agreement.
Right. Yeah.
And so that's what makes me think that the judge is more, like you said, like maybe he can't just let everything go from the law, right? He can't let everything go. But I think from the standpoint of like it being, I think my takeaway from the settlement conference was there's a distinction between creative process and not.
Mm-hmm.
And when I look at the two claims that they are saying are SH, two are for Justin Baldoni, two are for Jamie Heath. The
Mm-hmm.
rest of the items are totality of the circumstances. So to make it pervasive, not to argue severe.
Right.
When he really pushed Ezra to answer, or Ms. Hudson to push to answer, like, is there creative freedom there? I think she answered yes, like very reluctantly, but I think that both of the things that are claims against Baldoni are in a creative capacity. One, they are trying to make it hard that she wasn't in wardrobe when she said her outfit was hot or sexy or whatever. She was in wardrobe. There is video proof that she was in wardrobe. They're about to shoot a film, but the other party included depositions from Jenny Slate to say, yeah, I think she was wearing her own clothes, which is not true. There's video proof of that. And the second one is the birthing scene. And I read parts of the nudity rider, which was signed in 2023 before the birthing scene. And she is allowed to show, per her writer, any body part that you would see in a two-piece bikini, which includes her naked legs.
Right.
So that can't so then that goes into that judge's question about, like, where do these contracts play? Like, what is the point of a contract if that is what allows for that kind of freedom?
Right.
So I think Baldoni's points will be, I think Baldoni's both claims fall under creative,
right, like it's not
both of Jamie Heath's do not fall under creative. So that's where I'm more like, I'm not sure if he's going to let those go.
And I mean, so I was looking at this. I do think he will, but I think it'll be on the law. I think it'll be like, she's an independent contractor, so her Title VII claims are out, and then he's not going to give her. I was really surprised reading the oral argument how much he was like, is the ALA even a contract that we can enforce? I did not expect that. I don't know why I thought that was going to be more of a battle for them. He was just like, he doesn't seem enthusiastic about the ALA.
I just don't think it's enforceable. I think they're going to be operating off of the offer letter.
Yeah.
Which was fully negotiated and signed.
Yeah. And then I think so if he doesn't do the breach of contract, I did try to look at case law last night about false light invasion of privacy, because I was like, okay.
What did you find about that?
So, because I was thinking like, okay, so I said no to all this California stuff, right? Because I was saying like, it's the ALA that she's using for the employment thing. But then I did find some cases where somebody was able to sue for false light invasion of privacy because, and they weren't from California. And it's a little different because it's not an employment claim. So you're not having to use like an employment contract to kind of bring yourself into that jurisdiction. So I do wonder if he's going to let that. And the defamation thing, so the defamation is like just the Brian Friedman stuff. So it's not like any of the alleged smear campaign stuff. It's just the Brian Friedman statements. I ran this by Dan, the lawyer that I work with, and he thinks the defamation claim is going to trial. He said, I think that there's a gray area about Brian Friedman making those statements before they were actually in court. And he was pretty like strong on that. Like he was actually like, yeah, I definitely think it's going to trial. And I was like,
what date did he say that? What dates are Brian Friedman's statements? Like
Friedman
in
said
December?
it like end of December. So it was before they'd filed any lawsuits, but it was after the CRD.
But wouldn't they find a way to bring in Van Zandt? Because if they're trying to claim that that's all legitimate, then lawsuits had already been filed.
Well, it's after Lively's lawsuit. Their litigation privilege that they're claiming is about Wayfarer's lawsuit, which technically hadn't started yet because they hadn't filed it yet. So if he makes a statement, if Brian Friedman makes a statement on like December 22nd, technically there's no court case yet. I don't think they didn't know about Van Zandt, so I don't think they can say they're in court.
But now they do. So a lot of that stuff came in July. So I think even if it does move forward, there's a way to bring that up.
Well, and that was what I was talking about with Britt the other night. Like, if the defamation claim goes forward, I don't like that's a disaster for her. Because when you do a defamation case, you get to bring in anything that makes the person look like a liar. Like, you get a lot more discovery. You get a lot more admitted because you're using it to prove like the reliability or the credibility of a person.
Yeah.
And so I was like, wait, but that would be really bad for her. And it's like, yeah. So now I kind of want the defamation to go.
You're like, I'm really hopeful for this.
Now I want to see.
Do you think that they will use a lot of the stuff that's already come out in discovery?
Well, they would, because even if the sexual harassment claim gets dismissed, since the statement that Friedman made is she's lying about being sexually harassed, they could then bring it all back in. And they would get to bring it in to impeach her. Like, they wouldn't just have to bring it in to show what actually happened. They could bring it in. Like, so a lot of this stuff could still come in if they, especially if that defamation claim goes forward. So
I really don't see, maybe I'm just being too hopeful. And that's kind of dangerous too, where it's like, okay, well, maybe I'm just looking for like things that support, obviously, like confirmation bias. But my thoughts on that are, that would be setting a tricky precedent for attorneys.
Right.
And I just think that there's so much gray area as to when lawsuits started.
Right.
And when they, when they can say like, this is now, I can say this because you filed this lawsuit in July.
Right. Hi, Bachi, by the way. I just saw Bachi's in the chat.
She said she's en route to somewhere and she just wanted to come in. Oh my gosh, Bachi, we all miss you.
We do, but like, it's good that you're on vacation for you, not for us, but for you.
Yeah.
Let's see.
And what else do you think is still going to go forward?
Well, the civil conspiracy, I don't really know what to do with that. For civil conspiracy, everybody needs to have an underlying cause of action, and then there's the conspiracy to do that. So I guess, like, she's saying all of it is the whole smear campaign is the conspiracy. So I don't really know what to do with that, because what if like 3 people stay in and they have false light invasion of privacy? Then do they have civil conspiracy and like maybe the other people get dismissed? So I don't know what to do with that. It's kind of a weird claim. He might just dismiss the whole thing for civil conspiracy.
He didn't ask any questions about anybody else, like all the other parties.
I don't think they're going to stay in. Yeah.
Yeah. So it sounded like he didn't have, LGA told us something at the beginning of the conference, and she was just like, look at the questions that the judge is asking. That's probably things that, that he needs resolved in order to either make a decision or things that he's considering or thinking about. So in looking at the questions, he's not asking questions about any of the other 6 parties.
Yeah, and like I think let me scroll down because I put them all together. So
do you want to tell people what your color coding means?
Oh, my color coding: red means it's going away, and green means maybe it'll stay in. And then civil conspiracy is just no. And then I'm starting to think like, what's his reasoning going to be? And this whether this contract is enforceable. If the ALA isn't enforceable, all the red claims go away. So I think, Pam said, did you still think Steve and the PR girls? That's like the shittiest band name ever. I think Steve and the PR girls are probably done.
The band name.
Yeah, I think I think Melissa Nathan, the agency group, and Jennifer Abel, I think that Lively's not going to have the ALA enforced. And also, I don't think they're enough of the employer to have a FEHA claim. And then the false light invasion of privacy, she's not alleging malice. She has to allege malice. And there's no, and a conspiracy, you can't just have a conspiracy claim. You have to have like a different thing, and then it's conspiracy to do that thing. So that is, I think they're done regardless, and Steve is done.
Is there anything that caught your eye that you didn't expect? You know, because you heard everybody's summaries, you heard everybody's breakdowns. Is there anything else that you picked up that hasn't been talked about? Or maybe picked apart, you know?
Yeah, like I think, because, you know, you can kind of tell when he's talking to someone that he's questioning their case. Like he's hard on Wayfair and then he's hard on Lively, you know, and he's kind of, I think he is just very aware of how weak it is. And I mean, that's why I was thinking that settlement conference had to have been a reality check for her, because one of the jobs of the magistrate judge in a settlement conference is to say, here's the weaknesses of your case.
Oh, like, I didn't know that.
Yeah. So this was another thing I wanted to kind of, so I couldn't find Judge Lyman's stuff, but I could find this other judge who's also in the Southern District of New York to kind of give you an idea of what the parties would have known going into this settlement conference.
Oh, wow. This is really interesting. I haven't seen this.
So, yeah. So this is what they would have known going in. So, okay. So first of all, you know, and this isn't exactly necessarily the language that Lyman would have, because he would have his own policies, but it's the Southern District of New York. So I'm going to assume it's like fairly similar. So, you know, saying, I'm encouraging you to settle. So what happens is so all the settlement stuff is off the record. You cannot use anything from a settlement conference at trial. So they can say whatever they want. It's like marriage counseling. Everybody can say whatever they want. It's not leaving the room. Everybody work out your stuff. So the magistrate judge is the mediator, right? So she's going to talk to them. She's going to go back and forth. And I think there was actually a reporter who was saying this, that she was kind of watching the judge go back and forth. Lively and her legal team are going to be in one room. Baldoni, Wayfair, all them are going to be in the other room. And the judge is going to go back and forth and have this conversation, right? Like, here's what the case is, you know. So they're all going to have a conversation. The goal is to try and just put everything out on the table, right? So the big thing is, and again, this could be slightly different for Lyman, but it's probably close. Okay. No later than 5 business days before the conference, counsel must send them a pre-settlement conference letter and an attendance certification form attached, right? So they would have known going in who's going to show up to the conference. Parties, obviously, if you don't have a lawyer, you don't have to bring them in. But the letter, so they're going to be candid about the case. They're going to kind of say, this is the summary of the case. This is how we see the issues. It's a 5-page letter. They can attach exhibits, but they are saying a concise statement of the issue in dispute, the history of any settlement negotiations they've had so far, any offers, any demands, the evaluation of how they're getting to the settlement number, like their number that would make them settle.
So they have to bring a number.
They have to bring a number. Okay. And then strengths and weaknesses of the case that maybe they don't already know, and then anything else that's helpful for the court. Now, part of this would have come forward in the oral arguments, but not all cases are going to have oral arguments, so we wouldn't have that. So they have to make a settlement demand. So 14 days before, here's our number. So then the parties have to go to the conference. They have to. Everybody has to be there. Which I also thought was interesting, because I didn't see like Jennifer Abel or any of these people.
She was there.
Was she there? Okay, I didn't see her. So yeah, I only saw the matching, the twin flames, and Mrs. Baldoni. So then, business entities, they have to send somebody who has decision-making capacity for Wayfair. I'm assuming that was Jamie Heath. We don't have government agencies, and they made them do this. I did think it was funny he made them do it in person. So physically show your ass at the courthouse, not on Teams. So everybody has to go, right? So yeah, that's what, let's see, do they have? Okay, so following any opening remarks, the court will spend the rest of the time, so this would be Sarah Cave, their magistrate judge, meeting separately with each side. In these private meetings, the parties and their counsel should be prepared to discuss their position on and ideas for settlement, the reason for their positions, the strengths and weaknesses of their case, the amount of attorney's fees and litigation expenses incurred to date, and an estimate of the remaining cost of litigating the case to judgment. So how much have you spent? How much do you think you're going to spend by the end of this? So, I mean,
Wow.
what did she probably spent? 30 million. So it says the court encourages all parties to keep an open mind in order to reassess their previous positions and to discover creative means for resolving the dispute. Indeed, the court finds that a settlement can be achieved only if the parties adjust their expectations.
Yeah, neither party is going to do that.
Right. So, this is how it's going to work, right? This is, is it in person? Who are they going to bring? But yeah, the magistrate judge will sit down and say, this is what your case looks like. This is what I see. These are the problems you're going to have. This is how I think it's going to go. And she'll do it to both. And she'll tell Lively, I think your case is weak. Let's say she does, she says, I think your case is weak. I think it might get dismissed. I think a jury's not going to go for it. And she might go to Baldoni and she might say, I think, she's got some arguments. And I think leaving it up to a jury could be tricky, right? Maybe they'll go for it. Mm-hmm. And who knows, right? I said this in my jury video the other day, but I did bring up the possibility that like these smear campaigns are not retaliation yet. What if the jury decides that they should be? And they can do that. They can say, hey, maybe these smear campaigns are retaliation. Maybe we should have a law about that or a case law about that. And so she'd tell them, But then I did want to pull up the article. I don't know how I feel about whether or not she looked upset, but I'll show you.
I don't think she looked upset.
I didn't think so either, but I did think it says grim-faced Blake Lively. Is that grim? She looks fine to me.
She always kind of does this like open your mouth as you're walking, like so.
I don't. She looks fine. She doesn't look upset to me.
I think she was more worried about if she packed the mahjong set back, to take back home.
Maybe nobody would play with her. I mentioned the mahjong thing to Dan, and he was like, "Is that a game you can play by yourself?" And I'm like, "Does anybody in the chat know if solitaire mahjong exists, or is she paying people $3,000 an hour to play mahjong with her?" I don't know. But
what I would say about her air, about coming out, I distinctively remember her air when Justin Baldoni's case was thrown away, and it was, I am triumphant, I am, I don't know how, I can't say, but in her air was like, nothing can affect me, and she did not have that same air coming out. Okay. So that's what gave me the sense that it necessarily isn't good or bad. At least it isn't that. That's what I'm like. Look at the videos where she's wearing that white dress with I think it was like a jean jacket that she had on the side. She wasn't wearing it. I think she had it on the side or maybe over her shoulders. But she had a different air about her, and she did not have that air about her walking out of this court case. So that's why I'm like, I know it wasn't great, otherwise she would have come out with that same gloat kind of air about her.
Okay
Yeah, she's coming out like everything's normal, hi everyone, and I'm back in business,
Let's see, is it this dress? It says Blake Lively turns heads in a sheer lace dress following lawsuit dismissal.
You should see her getting out of the car and coming out, like there was this glow air about her, and she definitely didn't have that same glow air about her coming out of the court.
Let's see,
I knew it was like a jean jacket.
Yeah.
There should be a little video, but
let's see, and then we've got what's going on with the then we've got this. It is definitely a little bit of a different tone, but
so I was like, at least she didn't come out with the gloating tone. So I think that doesn't necessarily mean all good, doesn't necessarily mean all bad.
Yeah, this I guess must have been, I think this was on the way in. And okay, you can play alone. I was just curious. I was like, do you have to like make someone play with you?
Maybe she's going to get used to playing alone. We'll see.
Well, there is that. Let's see. Let me pull up the other articles. Okay. So I did appreciate the comedy of them kind of color coordinating.
Oh, I know. That was just hilarious.
Yeah, that That, and I mean, it's a good color. It's a good, it's a neutral. I don't know how
Here's
I feel
what
about.
I thought about that. You know how you spoke about this on your channel. You said
Mhm.
that you kind of like tell people what colors are good for what,
Yeah.
court dates. I think that they just talk to someone that coached them, and those people are both geniuses and great at their jobs, and they're like, go with this color. And they both
Yeah.
listened, and they both ended up with the same colors.
Yeah, I mean, where's my color theory? Let's see. Let me open my color theory thing if I have it. Let's see. Because I can never remember what all the colors are that you're supposed to wear and what they're supposed to communicate.
I think I from NAG's video, she said it was like openness.
Yeah.
You're wearing it right now. Is this on purpose?
Oh, my green. Yes,
Yes.
This is to signal openness. And then the purple in the back is for royalty. It's to lend an authoritative demeanor.
I love it.
Let's see.
Actually, green and purple are complementary colors, so they look really good.
Let's see. Let me.
Someone asked, when do you think we will hear from the judge? Sarah said mid-March the other night. Why then?
I think usually 60 days from oral arguments. And he's busy. He's got trials and stuff. So yeah, I think 60 days is like a good guess. There's not really any real logic to why I picked that.
Also, they do have to have time to prepare for trial.
Yeah.
Right?
Yeah. If he knows he's going to dismiss a lot, though, he may be like, you don't need that much time.
Oh, okay. I didn't think about that component of it.
Yeah.
I would think that even if it's not as much, it's still going to be a lot. Because I think that whatever moves forward, there's a lot of untangling to do with the jury, like to understand and to really break down the case. I think they're still going to need quite a substantial amount of stuff to bring to trial.
There's also a high probability he delays it again. Like he can just be like, we're doing this in August now. Like I mean, and federal judges can do that. Like they can just be like, nah.
You know what though? He did ask 2 attorneys to move 2 of their cases for this case. So he may consider that as well. So he's interrupted 2 other attorneys' cases.
That's true. Yeah. I don't know if you saw, I took down the video. I don't know how I feel about it, but I did this color theory video. So, yeah, green is natural, healthy, harmony, cheer, friendliness, and immaturity. And pink is femininity, sweetness, and liberalism.
See, I'm telling you, they probably just got coached by a similar, seasoned
trial
someone, trial fashion person.
And I went through all the law firms here. So Manhattan Phelps is yellow. Their branding is yellow. That's warmth, caution, fear, and cowardice. But also you can kind of see this in their slogan, right? We start with your needs. So it's warm, but it's also kind of like, meeting you where you're at, right? Then Wilkie is purple. So it's regality, intelligence, wealth, sophistication. And their motto is providing leading edge legal solutions on complex business critical issues. And they've got this very like fancy city in the background. So it's like wealth and sophistication and cutting edge, right?
There's that purple.
But I had to show you Friedman's law firm. This is all you see on the front page. You came here because you have a crisis. Relax, we will take care of it. And then it's black and white, evil, unknown, treachery, depression.
I would say professionalism. Let's get right to the point.
Yeah, it's I'm gonna pull it up just because it's so funny how this is what their website is.
I love it.
It's like, you're in crisis. Click a celebrity legal pit bull. So yeah, I was like, I wasn't expecting it to be so like intense. This is intense.
Hey, it's to the point.
Yeah.
That's hilarious. I like that you went the extra mile to put that together.
It was just because law firms believe in this shit.
Yeah.
Obviously they're gonna, but
That's interesting.
yeah, and then we've got our twin flames.
Oh my god, it's just so eerily similar.
Yeah. The first time they use a stylist, actually, this is probably I think this is actually the best overall because she's even got the green bag, and you know how I feel about the green bag.
You liked it.
I tried to. That's
Sony?
not the one I bought. I actually have. This is the one I bought because it was a quarter of the price.
Is that a Stony Clover bag? The one that she has?
The one that she's got. Yeah, it's like a $400 bag, and I think it's adorable. And I kept looking at it on the website. I kept going back to look at it because I was sharing it, and it sold out later that day. Just the green one.
Oh wow!
So clearly, other people were like reading People magazine and were like, "I like her bag."
It's a good color.
But I do like.
And isn't St. Patrick's Day around the corner?
It is. See, there you go.
That also influenced the shopping trends.
Yeah, but I'm like totally taking the wrong thing out of all this. Like, I like her bag. But then she's got $1,000 mahjong sets, which I'm not like.
You want to help support her financially?
Yeah, I'm not buying $1,000 mahjong set. From a person where they talk about the rich cultural history of mahjong and they talk about how it's American.
Oh,
I'm
wow.
Like, okay.
Someone asked, no rush, but what part of the retaliation claims go away if the SH dismissed, if any? If I've heard conflicting answers.
Okay. So you do not need to prove the validity of a sexual harassment complaint in order to win on a retaliation claim. You only need to prove that you have complained. So
and that's the one part in the oral arguments that I think was in Blake Lively's favor.
Mm-hmm.
I don't know if the Wayfarer part, obviously they caught it, but like they need a better way to address this because the judge said, you can't argue that it's not on the record that she believed she had an SH claim.
Yeah.
That's what he said. Like he said, it is on the record. So I'm like, so the judge does see it as that at least she believed that she had how did he say it? Let me find my note on that.
Yeah, I mean, I think he thinks the 17-point agreement is protected activity, specifically because she said, I'm doing this in lieu of a formal HR complaint. I think the question that he's gonna have to answer is, did she waive protected activity? Like, is saying I'm not going to make an HR complaint waiving your right to engage in protected activity? But I don't think he's going to dispute that at some point she believed that she had a good faith claim.
I don't think, man, I that's what I'm like, okay, run that back for us one more time. Say that piece one more time.
So what I think the dispute is going to be is that 17-point agreement. She complained and she said, I'm doing this in lieu of an HR complaint. So he's going to say, like, that can be protected activity because it shows that you had a good faith belief that you were sexually harassed because you're talking about an HR complaint. But then what I think he might say is she waived it. That was the consideration for that 17-point agreement, is that she waived protected activity.
I guess my thoughts are that I don't think he concluded that she waived it.
No, but I think he could.
He could now, but I think at the hearing he didn't already come with that notion or like that's something that he said.
Mm-hmm.
My thought is like maybe just that eventually Wayfair heard whether she wanted them to hear it or not about the call with Sony. I don't think that is what they're claiming is their protected activity, because that's not, that he asked them, what is in your view protected activity, and they pointed to two actions: the 17-point agreement and the fact that she didn't want to take photos with him at the press,
right,
at the premiere, and those two are their protected activity. But I just don't know if that 17 point it could be protected activity. I mean, and if it is, it did get resolved. It did get resolved, and it is on record that it was resolved. Right? They said they didn't have issues after that.
Right.
And I think NAG made a comment about that, like, but I guess that's where you're saying like the retaliation component of that may still live, right?
Well, no, because I still think the California thing plays in. I still don't think that. So he may dismiss this law in California and not even have to address this. But what I'll be interested to see is if he does address it. Yeah. So
like if he does allow the California stuff to go.
Yeah, I mean, I think the only way to get the California stuff in is to say that the actor loan out agreement is enforceable. I think those two are tied inextricably. So I think if he does that, then that's a little different because you're saying that there is a contract. And I don't know. But if she waived protected activity, then what it means is there's no retaliation because there's no protected activity. Ooh. Essentially, she has forfeited her protected activity claim. Right? Because what she's saying is, I'm doing this in lieu of a more formal HR process. Now, the problem with that is that they do say something like, we're reserving all rights. So, I mean, he could just say there's no consideration for that contract. And yeah, that's kind of what I think he was at one point saying, like, well, what's the consideration?
Also, he did ask them, is there anything that she did not get? And they kept trying to not answer that. They kept trying to not answer that. They kept saying like, oh, well, it shows that there was something that she could not get if she didn't ask for it. And he's like, yeah, but did she not get it? Like, what did she not get? And they were like, nothing. Like there's nothing that she did not get.
Yeah, and I see, when I read the oral arguments, the biggest thing I see for Judge Lyman is that he says, and I think this is where you see a judge saying, you're backing somebody into a corner that I don't like, where he said, like, so with fee, and this is why I think those California claims are done, because they're saying, well, okay, like California law, how does this apply to her other than the actor loan out agreement, right? So that's the thing. He just kept going back to, well, what if I don't enforce this? What if I don't enforce this actor loan out? And I was like, really? Okay. And then at one point he says, is there anything that the California legislature could have done if it wanted to make sure that its laws were not deployed for people for whom they did not pass the law? And that is a sign that what he's saying is, are you going to start telling me what the intent of the California legislature was? And you're an attorney in New York, you know, and I've got to now decide that the California legislature intended for these laws to mean this to people in New York. And he's not willing to do that. Like he's very unwilling to do that. Right. So he's kind of saying like, I'm not going to extend California law.
He said, it's something I can consider.
Yeah, but he's not enthused.
Yeah, he's like, it's something I can consider, but I think he's also, that's why I'm like, man, he has to apply a lot of wisdom to this order.
And this is the thing I was kind of saying at the beginning, where he said, like, because they said, you know, the parties can stipulate to California law. They can stipulate in a contract to California law. And then he says, yeah, I mean, I know the lawyer said that, but I don't understand why that has anything to do with me, right? He's like, I'm supposed to figure out, like, I understand that you guys can sue each other for breach of contract and you can agree to what laws govern the contract. But you're saying that this is an employment claim that she now has access to because of the choice of law in her employment agreement. He's like, I don't understand why I have to do that. And I just feel like for Lyman, when he's saying, I don't understand why I have to do this or why I'm bound by that, I'm like, yeah, he's not going to do it. Maybe. Obviously, I'm not.
Yeah. I think he has to probably find something to justify his obvious stance on it.
Right.
As to why he can't do it. Like you said, maybe write like a really long order as to why he's choosing one thing over the other.
Yeah. I'll be curious.
Go ahead. Sorry. I said, do you want to do a recap? Because some people.
So we went over the settlement agreement and then matching outfits, and now we're just talking about the oral argument.
Openness.
Yes, openness and neutrality and femininity and natural. Um, yeah, so now we're just talking about the oral argument and which claims might go through. And I didn't get to read the oral arguments until recently because I didn't go. And so there, yeah, she was just, I mean, there's not really anything that I think the attorneys didn't point out other than he's very stuck on the law. He really didn't, I think, address the motion for summary judgment very much, like the facts of things. I mean, I know they talk about the harassment itself, but he's kind of using that. But if he waives the employment claims for California law, he waives the sexual harassment too. So it doesn't matter how severe or pervasive anything was. I also don't think he's going to do the spoliation.
Yeah, he didn't spend any time on the spoliation. He was just like, okay, thanks, sit down.
Yeah.
Yeah. I went over some of the stuff because, you know, I'm having to log this all in there, and there's really nothing substantial to the spoliation that he can go off of. You know, like for example, NAG mentioned in the Megan Thee Stallion case where she did win spoliation, she said there was a thread text message that Megan, you know, got through Discovery, and the conversation was going about, like, they're talking about Megan Thee Stallion, and then it's like, oh, we got to a point, and they deleted everything.
Right.
And then it's obvious. It obviously states like this is what they were talking about before, and the deletion of the stuff seems pretty clear. When I was entering all the spoliation communications, nothing was like described like that.
Right. There's not an obvious.
No, the some of the spoliation evidence that they included just included like voice notes. I guess they included it because it shows it was a voice note that they sent.
Right.
Or
right.
it was, so it wasn't really like the chats weren't relative, like didn't really have any substance like that. It was just that they had voice notes that they can't access anymore. So that's why I'm like, Oh, you, Kira, you do that after the live. So when Sarah finally posts, you'll see at the bottom it says comments, and then if you slide over, it'll have a hype, and you can hype Sarah's video.
Oh, I don't know. I've never done that. Yeah, so yeah, I mean, Saucy Nuggets on TikTok says, I know some think he may, but I wonder how you get intent. And it's like, yeah, I mean, the thing is, it's a novel theory of retaliation. So the argument that they knew they were destroying evidence is kind of like, well, how did they know they had evidence? You know, maybe they knew, even if they had
so that's evidence. What I'm getting at is like the evidence that they gave in support for saying, oh, they knew litigate. There's nothing like that. There's nothing of substance that shows that, other than the text messages that they included had voice notes that we can no longer see.
Right. And and Lyman's not going to say the use of Signal is proof that you're destroying evidence, because immediately there's going to be a bunch of lawsuits about that.
Yeah. I mean, that attorney did, I think he did a good job at trying to lay it out, but it's just, I was like, oh, all right, son. You got your 20 minutes. Sit down.
Bruno's his name. Yeah. I was like, who's Bruno? I did see him in the argument. I was like, I've never seen this guy.
Oh, I recognized all the attorneys when they were walking through. And some of the girls were mean mugging. They were mean mugging NAG and LGA. They were like this.
That's when you know you've made it.
And I was like, it was like attorney girls or intern girls that were mean mugging them,
because they have to watch all their content. They have to watch their stuff so that they can make sure see what's going on.
Those girls, or maybe they were looking at Andy. I don't know. But that was kind of funny.
So yeah, I mean, I did my like jury video the other day, and I was just like, I don't know if I don't even know. I had to do like let's pretend this is all going to a jury, because I don't think it is.
I think even if it goes to the jury, like if it does, I think that they have to find 12 unreasonable jurors. They have to find 12. And I think that they'll find one or two that are like, yeah, like this is. I just don't think that that's a reasonable stance. It's not a reasonable amount of money that she's asking for. It's not.
Mhm.
It's not reasonable, and they're just going to have to find 12 unreasonable people to agree or come to a consensus that that's what they're going to do. And I think that that's a challenge. So whether it's now through the judge or later, I think that I don't know. I think that the result will be the same. Like there's just the case is weak and the result will be the result of the case. Now that I do think that Wayfarer needs to find a very clear-cut way on how to present the case, like in their opening briefs. I think they need to be careful with the words and how they pose it. I've heard NAG's arguments, and I've heard like the things that they should consider and stay away from. So I think that there is a trickiness, like the chatter with some of the millennial girls at the court. I've never met them. They just look like millennials. And they were like, oh, we didn't like that a guy was presenting these the essay component. I didn't like that. And so they're going to have to be careful. And I'm like, ooh, they should have put forethought into that. But I guess they weren't thinking about like, hey, people.
They're not thinking about the jury. They're thinking
right now they're not thinking about that. They're just thinking about how do I get through to the judge. And so I do think that they're going to have some sort of challenge in how they present it and how they're going to deliver that. But I guess once they whittle down the claims or what goes forward or what doesn't, that's going to be, I think, what's going to make it clear cut or ease the path.
It's so hard to know what's going to happen because it's like, is he going to just demolish this whole case? Like there's a world where none of this goes to a trial, where he just dismisses everything. Like
and I don't want that either. No, just kidding.
He says no California, no malice, and then all you're left with a civil conspiracy, and there's no underlying tort, so everybody get the hell out. And like, yeah, I mean, it's kind of that would be merciful for all of these people, everybody.
I would get so much of my day back.
And it would be good for Lively. It would be good for Lively, even if she doesn't want to admit that. It would be good for Wayfarer in a weird way. I don't think there's more PR benefit to either side at this point. I think people are kind of entrenched, and I don't think more trial is going to make this better. I'd love to know what the magistrate judge said. If she just like sat down and was just like, so why the hell are we here?
Wait, do you think, and I thought, oh, you know what? I'm going to ask Sarah this because you may know better. So we've seen the evidence that they used for their MJOP and their MSJ, and we've seen that. But there has to be more evidence behind the scenes, right? About whatever. Because this is only for the things that the judge needs to rule on to make it go away now. But that doesn't mean that this is it. Like, I'm sure there's more text messages about Ryan.
Yeah, and if I had to guess, we are seeing 70% of what Wayfarer has, and we are seeing 100% of what Lively has. And the reason I'm saying 100% is because she's at such an edge of getting the case dismissed that if she has anything, she needs to throw everything at the wall right now. There is no sense in her holding back, especially on the smear campaign and like the adverse action in August. And then on the sexual harassment, those are the things where I think we are seeing everything. Because if she has something, she needs to put it out there now. That's why I think she's putting the expert stuff out there, because the experts are essentially her evidence.
And also, that's why she filed so many sanctions, so she could get additional evidence out
there. Yeah. Yeah, I mean, she might have more stuff from maybe like January, or the Friedman on something that she might be holding back. But I think we're seeing everything from August. And like, this is the thing: the experts can't make your case. Like, you can't have an expert just testify that because again, it's like that Darvo expert, right? Where she's talking about what Sony and Wayfarer did, and it's like the reason why they had this happen. Okay, so first of all, both sides said no expert reports in the motions for summary judgment or motion for judgment on the pleadings. And the reason why they said that is because that way, when they do the response, Lively could still do it. But since Wayfarer didn't have a response, they couldn't do it. So So like Lively has these expert reports she wants out in front of the world, right? If she'd filed a motion for judgment on the pleadings or motion for summary judgment, they said no expert reports for these motions. But they didn't say no expert reports for the response.
Or the replies, yeah.
Or the replies. But then they only get 30 pages. They only get, I think, 10 pages for the reply or something very small. It's like 60 pages, then 30, then 10.
And
so
they're not all of them.
Yeah. And so she threw all of her expert reports into the response. And the thing is, when you're reading the experts, it's like, this is her narrative. And this is like, her, if you were to read her experts and you didn't know anything about the case, you would read her expert reports and you would think, she has a really strong case, right? They're seeing this amazing. And then you look down and there's 20 exhibits that they have. And you're like, where's the PGA letter? I already know what I'm looking for. It was funny because when I saw Not Actually Golden's video, I did my video and then she did hers and she hadn't seen mine yet. And the first thing we did was Control F and look for the bait stamp for that PGA letter with that Darvo expert. Like, where's the PGA letter? Where is it, Dr. Freed? And they didn't give it to her. So again, it's like another cherry-picked testimony. Yeah. And I'm like, this is it. This is her case. This is her best argument. And there's, you know, well, if you take out all the evidence that makes me look bad and you only include the evidence that makes me look good, it turns out I win. It's like, yeah.
Yeah, that's normally
how it goes.
Yeah, like how you think it would go in actual court, but no, sweetie, no.
Which, you know, maybe that's why she's bringing the mahjong set. She has the experience of winning in court.
So, let's see if there's any questions. Yeah, that was the first thing I did with most of the expert reports. I just looked at what did they analyze, and they didn't analyze anything that Lively gave them. They didn't analyze any of that. I'm like,
and I mean, that's the thing. Don't get mad at these experts, guys. They only have what they have, right? They don't know what other evidence might exist. It's
someone said, who do you think Blake would sue first if her case is fully dismissed?
Ryan. That's who she should sue. But if she sues her attorneys, I would assume her attorneys have had her sign something every step of this process saying, I'm not going to sue. I understand what the risks are. Then again, anything she's ever signed with Wayfair seemed to just get thrown away. So
she's probably just like still negotiating those with her attorney.
She's going to file a sanctions motion against her attorney for not doing her case properly.
So someone asked, when did Brian Friedman make the statements in? So that's what Sarah was saying earlier, that Brian Friedman made his statements after the New York Times thing was released, but before their own case was filed.
Yeah, let me expert reports.
Yeah, the Darvo lady. I wish Wayfair, Rachel, I wish Wayfair had gone to the Darvo lady the moment that they threw that word out.
And I mean, I think I feel bad we're calling her the Darvo lady, but I think the thing with Freed is that she's not, you know, she's saying what the research is, right? Which is that if someone is guilty, they use Darvo as a tactic. If someone is guilty, if someone is an abuser, they use Darvo as a tactic. She's not finding that Wayfair is, because that's not her job. Her job is to say, if they did sexually harass her, here's other stuff they did that contributed. She's not finding that they sexually harassed her, right? That's the fact that's a jury thing. The jury has to find that happened. She's basically doing this to say it's even worse. And also, I think, to put Sony out on blast, which was the dumbest thing she's probably ever done. Let me see who. Okay,
maybe their fallback is Paramount.
You're gonna run it. I mean, how long is Greenstein gonna be there? Let's see the at issue statements. Okay, that's not her. I'm gonna pull up because this expert has like a great.
While you do that, I'm just going to run through some of the questions. Someone said, just got here. Did y'all talk about the New York Times article? Not yet. That is after. That's the second half.
That's the second half. Yeah. Let me see.
And it seems like the expert reports did not get much traction in the mainstream media. It could have been milked harder, but wasn't. And they put in parentheses, I'm glad. I think that they're probably saving it for when they get dismissed.
Yeah.
How about Miss Darvo lady? Yeah, that's what Sarah says is Jennifer Freed. She did not review the PGA letter, and she only reviewed like 20 documents to come to the conclusion. It was ridiculous. And like NAG said in her video, like the purpose of that was to use it for PR. They got what they needed out of that, and that was that. Like she's not going to be helpful in court. She's not going to be helpful.
Yeah. And this is what I said. This is what I said in my video as well, because it's going to take 10 seconds to say, did you have a chance to review the PGA letter? And then she's either going to say no, in which case, you know, why didn't they give it to you? Or she's going to say yes. And then they're going to say, do you still agree with, you know, that if she did this and she had this control and she hired these people and she did all of this and she was across HR, do you still think that means that she doesn't have any power? And she can't win. If the expert says like, no, she still doesn't have any power, the jury's going to be like that. Then why didn't they give you the report? Right? How come they didn't give this to you at the beginning? Why did they hide this if it doesn't matter? Obviously it matters. Or she changes her testimony on the stand. And it's like,
I think she'll probably answer like Michael Robbins, like, no, it's not my job to review that. To review that. So
they'll say they can still ask about it though. If she says, oh, I don't have that, you know, I haven't seen it, they can still ask about it. And that's part of her testimony. If you knew that she was hiring people and she said she was the head of HR, would you stand by your analysis? And if she says, well, I don't want to answer that, the jury's going to be like, well, obviously.
Yeah. Rachel, you mentioned that we don't know what she's going to say. Her report is out. You can see that under docket updates. I put it under the depositions. We don't see her deposition, but you'll see her report. So what she has to say is in that report.
Yeah. Yeah.
And if you guys want to check that out, it is under depositions. And then I put an additional button for the experts to attach their reports. I think I'm still missing like 2 experts on there, but I'm so deep into this timeline that I haven't gotten a chance to do that yet.
Let's see. Let me just look. Okay, the at issue statements. I think I got to show you now that I've seen this. I got to show you guys this. This is my Roman Empire. Is this graph? Where is it?
Whose graph is it, Sarah?
It's Ashley Humphreys. She's an expert witness. And this is like imprinted on my brain. Because
Humphreys, guys, is Blake Lively's expert.
Yeah. One of her smear campaign experts to show how the smear campaign happened. Where's the graph? I just had you.
That look in your eye is just too.
Okay. Let's see. It's this. So, sheriff respondents who are familiar with Miss Lively and view her negatively. So, these black bars are from October 2023 through June of 2024. So, before the premiere of the film. And you see an average about 6% familiarity with her that view her negatively. In July through September of 2024, which is the height of the smear campaign, this is when she says it was at the worst, it's 8%. And then look at January through June of 2025, it's at 12%. The lawsuit has done more damage to her reputation than the smear campaign in August.
Mm-hmm.
And
because I would say, like, I'm part of the people that was in the black graph. And then when I watched the movie, I was really confused. I wouldn't say I was talking bad about her, but it was just like, I literally thought this was a rom-com. I went to the movies by myself and I told my husband, oh, no, you're not going to like it. It's a rom-com. And I went by myself. I was very deeply confused about the movie. I had to chat GPT some of my answers. And I was like, was he in love with Atlas while being in love with Ryle? Because that's what I got from the movie. And I was like, why didn't she just leave Ryle if she was so in love? Or like all these memories came back about this other person.
Right.
And so anyways, I was frustrated, but I wouldn't say it was negative. And then I'm part of the red graph now.
Yeah, and I didn't know who this person was until the red graph. So Yeah, I think where's the other graph? I think it actually might be Maislin's. The other thing, and again, this is like I made another video about this because this is another expert jury. Oh wait, an expert witness thing, right? So I think I pulled this up, and I was saying,
I think I saw a little piece of this. I didn't get to finish this video.
Yeah, so this is in her expert report, right? And she's saying, like, here's an example of the negativity that Blake Lively is getting on the internet. And it's like, okay, cool. Let's read the comments that this expert decided to pick. You may subpoena all the poor, real people who give us real facts and find fake evidence to falsely accuse people and misuse law. But get this in mind, there is nowhere in the whole world where people will like you. We will never forget. You can live in your own bubble, pay whatever money you are left with to have fake fans, but you will know we will never want to see your face ever again. And it's like, okay, you may subpoena all the poor, real people. So what is this person responding to? They're responding to the creator subpoenas. This was done in like June.
Mm-hmm.
And it's like, yeah, so they're going to ask, what do you think the subpoena thing is referring to? Or, I think even the jury will be like, what do you mean you may subpoena? Who are you talking about? Who got a subpoena? Mm-hmm. And it's like, what is Brian Friedman supposed to apologize because her attorneys decided to subpoena a bunch of content creators? Mm-hmm. I don't know.
The backlash has to go to someone, and it can't go to the attorneys, right? And so,
well, she could sue for malpractice.
No. I mean, the people that hate on the move, they can't really hate on the attorneys. They got to hate on the person issuing it.
Right. Yeah, it's just
no. Yeah. Look, she has all. She got all this evidence. Only 16 people fought back their subpoenas out of the 107. So
I don't think I don't think companies necessarily complied. She would have to resubmit them with those people excluded. So like if one person has successfully fought, she'd have to resend the subpoena with that person removed for Google to honor it.
Okay, because I did see that her attorneys filed the things to remove those 16 people.
Oh, okay.
So they did.
Well, they withdrew. No. I mean, they withdrew them. But if they sent a subpoena to Google and it has Alice, Bob, and Charlie on it, they need to send a new one with Bob's name removed if Bob fought his.
Oh, interesting.
So okay. I actually don't think that they went ahead with the subpoenas. I really don't. I think they just did it and then they didn't.
Yeah, it didn't pan out.
Yeah. So if they get a subpoena and one of the people is removed, they have to submit a new one. So.
Interesting.
It's possible she didn't get anything. And I think it was just a PR move. It was just to say,
stop talking about me.
Stop. Yeah. Or to try and rile people up, no pun intended, against random YouTubers talking about the law. This is the other thing, similar chart from one of her other experts. So we have this peak here, which is the peak of the smear campaign, right? Volume of online conversations, and then it just dies. And then we have the loss.
Just let it go.
Well, right. And it's like, okay, well, this dead air. And this is the biggest thing I think they're going to do for a jury if this gets here. My whole theory was, well, Jed Wallace didn't get paid to do nothing for 3 months. And it turns out he got paid to do nothing for 2 months because 2 months of this, there's no conversation about her. So what was he doing? I don't know what he was doing, but this does validate the idea that what he does is passive. Because if he was working for these 2 months, you would see more conversations about her. And instead it just dies. Almost like it was organic.
Mm-hmm.
But yeah, this
had already moved on. Yeah.
Yeah. And so it's like, you're telling me he's still doing all this work through the end of October, but that's right here. So what was he doing? Well, he wasn't doing a very good job. If this is the smear campaign.
Wow.
But her lawyer, and then,
yeah, because that's what I'm saying. Like, I watched the movie. I did some digging on my own. I didn't get far. I did see some videos, but I was just like, like, I already watched the movie. I already spent the money. Oh, well,
yeah.
And then it was like not that interesting until after
the lawsuit. The lawsuit's more entertaining than the film.
Yeah. What did Ryan said? They'll be making a film of the film.
Lights cult to action. That's what she said. He's probably going to be making Easter eggs for it for the rest of his life.
Oh, but you know what I love? I think in my head, I'm like, I just hope he fears for the rest of his life who will have access to his messages and what he says. And they're just going to be paranoid for years to come. So
I wouldn't want to piss off a billionaire, you know, like, and Sarah said,
anyone at that point, because imagine now people know what you did and what you're capable of and what you're comfortable of doing, where your ethical lines are. So if you ever try to pull one on me, I know exactly with who I'm dealing with.
Yeah, I mean, Jed Wallace basically is like, okay, well, let's go. I was just monitoring, and actually somebody said this here. I was just monitoring before, but let's go. After reading a few excerpts of the Jed Wallace text, it appeared to me he was hired to monitor the smear campaign Blake waged against Justin. Did I misunderstand? Yeah, I mean, and he's been saying that. I just pointed out that, like, I didn't necessarily believe him. I mean, I thought, let's see what the evidence is. But 2 months of this, he was getting paid to do nothing. So, yeah, I think that this, to me, I think is like, her expert is saying very little was happening in September and October. So, he was getting $30,000 to do something that didn't show up in her negative mentions or didn't show up in around her name. And this is her data. So.
And do you mind spotlighting Rachel's question?
Oh.
I think she has one.
Is this one?
Jennifer Freed. Yeah. Uh-huh.
Yeah. How can this not show that Darvo Lady believes she was a victim in the jury's eyes? So, I mean, the expert cannot testify to whether or not she was harassed. That's a fact issue. What the Darvo Lady is saying, the Darvo Lady, I'm so sorry, Dr. Freed, I'm sure you're a respected psychologist, but what Dr. Darvo is saying is that she...
Dr. Darvo.
What she...
You're like, let me put some respect on that name. Dr. Darvo.
Dr. Darvo. It's Dr. Darvo, not the Darvo Lady. She has a PhD. She cannot testify that Lively was harassed, right? What she is saying is that if she was harassed, the Darvo tactic of making her look like the abuser or the aggressor in the situation made the situation worse. But she's not testifying that Lively got harassed. She's just saying, like, there appears to be an institutional failure that made everything worse. And, like, the thing is, what it feels like is that she's testifying that Lively got harassed based on a handful of documents. And that was the point. Was to get this out in front of people. So, I mean, she did her job. It's just kind of like a poor way to treat an expert, I think.
I think that the summary or the takeaway would be that it's impactful for now. It's not impactful for trial because she lacked a lot of the information
right. And that's the thing. It's very easy to impeach her because the question is, why didn't you see, have you seen this PGA letter? Then they start asking her, do you still think she was a victim? And not a victim, but like a lower on the power dynamic. If she was across HR, if she was making all these decisions. And then either the expert has to change her answer or she says, no, it doesn't matter at all. None of this PGA letter matters. And the jury's going to be like, so then why didn't they give it to you? And they do notice stuff like that. If they feel, especially with experts, this is something juries are sensitive to, is like, was the expert fully prepared or is the expert just being given? They think juries are very sensitive to, like, are experts just being paid to say something? And they don't necessarily think like the expert's a hired gun. It's more, well, do you have all the information? They'll notice that this is cherry picked. So I don't think they're going to use her. I think maybe they know they're getting dismissed, and so all of this is going to be moot here. See, didn't Judge Lyman make a witty comment, something like retaliation must not have been that successful? Yeah, he said that Colleen Hoover. He said there was a dinner where they were saying negative things about her to Colleen Hoover. And he's like, well, that wasn't successful. Because Colleen, if anything, that drove Colleen over to Blake's side.
Right. So the way the Lively party was trying to say that the retaliation started when they were bad mouthing her to Colleen Hoover. But Colleen Hoover went straight to Blake Lively and said, oh, I don't like that. And so the judge said, so it wasn't successful. So it's not a fully executed successful retaliation. It can't be retaliation if it didn't harm her, if there's no damage to that action.
Right. And it also has to be somewhat, for FIHA, it has to be somewhat related to your employment. Like, they can talk shit about, your employer can talk shit about you after you leave. Just so you know, guys, that's in the law.
Is that something that also came up in the McSweeney case?
Yes, I will say the McSweeney case is different in one major thing, which is that litigation was being threatened. And so when litigation is on the table, Lyman's like, once it's litigation, you guys have taken it to the street. It's not an employment thing anymore. You guys are suing each other. And how he puts it is no employer should be expected to lie down in the face of litigation. Which I think he's going to say, Lively can't use any smear campaigns that happened after December 21st. Mm-hmm. I think so. That's why the defamation thing could get interesting, because some of that was before the 21st. So let me pull up those statements. Let's see.
Did you want to read the entire article for the people, the NYT article?
Sure. Yeah.
Do people in the comments, like, do you guys want Sarah and I to read the article for you all, or no? Or just summarize? Comment below. Comment. Like, subscribe.
Let's see. And then let me see if I have the expert. Okay.
I was like, if Bachi was here, she would be reading it for them.
Let's see. I honestly didn't really prepare well for this. It helps that I have a million things. This weekend, I am doing my first ever looking at an actual case that is actually going to court to tell them what I think will work, what arguments I think will work with the jury and won't.
Ooh, how exciting.
I know. As opposed to just talking about it with celebrity lawsuits on the internet.
So do you ever get to talk about your cases afterwards, or no? Or
No.
It's like a confidentiality thing?
I have an NDA, but I can say that much. I can say that I'm able to look at this.
Oh, how cool, Sarah. That seems pretty fun.
I know. So I'm like, oh, now I get to actually do it. And then, I was thinking, like, are people okay with non-lawyers doing this? But I honestly, Britt said something like, I think jurors are fine with it as long as they win. Right. Mm-hmm. All right, let's see these at issue statements. Where is it? I know I have it down here because there's a list of. Okay. Humphreys, page 61. I have no organizational abilities on this computer. I don't know why.
Oh, how's your new computer? You like it?
I like it. Yeah. It's
awesome.
Helpful to have. Let's see. That's why she has a hyphen in it. Okay. Defamatory. So, yeah, and I think the defamatory statements might wind up, let's see, it's page 17. That's a different report. That's 54. Let's see. It gives real people a perspective, which really helps attorneys that aren't exposed much to real people. Yeah. Yeah, and I mean, there's a science side to it. There's an academic side to it. It's going through there's jury stuff. Like, people think, oh, I'm going to make this argument. It's going to work really well. And I'm like, I've never had that go well once in a mock jury, But, they think, oh, like a lot of people spend lawyers spend a lot of time on their clothes. They think if they wear like a particular suit, the jury's going to like it. And I'm like, I don't think they're going to care, but all right. Humphreys part 2. But the defamation claim going forward is not something did he say much about the defamation in the oral argument that you remember?
Defamation.
Like Brian Friedman's statements.
He didn't like them. The way that I guess I picked up from it was like, like that seemed to have gone too far. He used some word like that. Like it was like, well, that goes beyond. He said something about Brian Friedman's statement. Like that goes beyond fierce advocacy. And I'm just like, how does he conclude that? Because that sounds like fierce advocacy.
Right. And then it's kind of, so this is, that's going to be, I didn't really think of that as being like a thing that could happen with the defamation going forward. But okay, so so the at issue statements are what she has a whole expert devoted to the at issue statements. So, okay, so I understand that Ms. Lively alleges that certain remarks were defamatory. Now, remember, this isn't even saying that she's going to prove that they're true. Again, they'd have to go through the malice thing. So not only, even if they go to court on these defamatory statements, she's going to have to show that they were made with malice, that Friedman does not believe that these things are true. So so it says the ad issue. Okay. So December 21st statement to the New York Times, a January 7th, 2025 interview to Megyn Kelly, and 2 January 18th, 2025 statements to Deadline, and a January 25th, 2025 statement to Page 6.
But see, that was after January. They would have to be before litigation, right?
I think so. Well, I guess it depends. Unless, let's see. Do I have a list of the actual?
Give us your thoughts. Give us your thoughts.
I mean, so she goes through, let's see. She does put down most of her defamation or most of her damages to these statements.
Which is kind of, I think, wild. It's wild.
Right. I'm suing for a smear campaign that didn't start till after I sued.
And then, or just, I'm suing for a smear campaign that didn't affect me as much until the attorney started speaking.
Right. And now I'm adding that in. Let's see. Okay, so let me just see. Okay, the at issue statements assert that, among other things, Ms. Lively made false accusations against Mr. Baldoni, Wayfair Studios, and its representatives, and that she pushed a self-serving agenda in her accusations to take control of the film. They also explicitly state that Ms. Lively's allegations of sexual harassment are false, and that in actuality, no sexual harassment occurred. Additionally, I understand that Mr. Friedman has continued to make public statements about Ms. Lively following the filing of this lawsuit, which repeat similar themes about Ms. Lively making false accusations and being a bully. So she would have to go to court and she would have to say, all of this is untrue, and Friedman knows it's untrue. And Wayfair and all of them know it's untrue. Actually, I should say Wayfair knows it's untrue because he's making these on their, he's like an agent of theirs. So, all right, let's see if we have a little more detail about what it is. Okay, this is just millions of times that people saw this, 116 million impressions of these statements.
I had a top comment when the Megyn Kelly one came out, so maybe I'll be in the next filing.
There you go. You could always be I've been in one court filing.
You have?
I have a YouTube comment. A YouTube comment was in Without a Crystal Balls lawsuit.
No way.
So, yep.
Wait, this lawsuit or a different one?
Different lawsuit. Yeah, different lawsuit that she's been in for a while.
And you were a top comment there?
I was. It was on a different account. It was during the pandemic, I think. And I was in a lawsuit, and I was like, neat. My name in lights, not really what I thought was gonna happen. So let's see. I don't know. Maybe they don't put like the actual quotes. Let's see. At issue statements. I mean, let's see. I do think this is kind of funny. Social media influencers covering this matter have also framed Mr. Friedman as a credible source of information about the matter. Let's see.
And I'm sorry, Ms. Lively, who do you want us to be the credible source for this litigation? Only your attorneys? Only?
I mean,
the New York Times?
Let's see. I used to be able to. Oh, I guess I have to be. Let me see if I can do this in the live chat. I'm going to try and make a poll. I need this to be a little more interactive, I've decided.
Oh, I like it.
Let's see. Okay. Here we go. Here is a poll. Do you find Brian Friedman. Incredible. Let's see, I don't think we'll be able to see the poll. Oh, I guess I could do this. You're going to see my face paused. Let's see.
Oh, how did you see that?
Here. Cool. Yeah, I was doing it. Oh, wait. No, never mind.
Oh, how cool.
Yeah, there we go. I also, here's a pro tip if you're ever doing a poll. Switch no and yes in your options because people like to click the first one.
I just clicked the first one accidentally.
Yep, that's what people do all the time. So that way you don't skew your poll. They have to actually read the options because you switch it up every now and then.
That's awesome. I actually didn't see the poll. It was by accident. I didn't see it. I have it here on my phone, but I was trying to scroll because I thought it was going to be down, but I accidentally pressed it.
Let's see. Oh yeah, we should pose because we're probably going to get screenshotted for the lawsuit. There we go. Please use that screenshot.
That's
all right, 15 votes. Yeah, but if I'm ever asking a yes or no question, I always like to put no at the top because half the people are just going to be like, click first option. It's definitely yes.
That's a good one.
Yeah, if you're ever doing that, if you're ever like asking a survey and you're doing multiple questions, switch them up so that people have to actually read the options.
Good tip. Good tip.
There's your survey tip for the day. All right. So yeah, so I mean, Perez Hilton's talking about Brian Friedman in a positive way. I think there's a tweet. I told people on my live that this was Chris, the PR guy. It's a quote from Friedman, and it says, Justin Maldini's lawyer slams Blake Lively's lawsuit, and then somebody quoted it and said, I trust him, and it's Chris. So I just said it was Chris, the PR guy, and I think some other people were like, really? I'm like, yeah, no. He's really switched sides since the beginning of this, guys.
No.
Let's see. So, I mean, they're using this to say this, like, I don't believe her. I mean, he doesn't like Friedman. Maybe he'll let this go through. If they let it go through, she remember, that means she's going to have to prove that they're lying. So, I mean, she's going to have to go to court. Let's see. She's going to have to go to court and prove that she isn't a liar. That is a really tough thing, by the way, for anyone to do. I mean, just regardless of the situation. Here's like the Blake Lively is a liar hashtag. And I did think this was interesting because this red bar is like when the at issue statements were made. So you see this peak over here. Actually, I don't know if the mouse actually does anything, but it's this really high peak over on the right that isn't red. That is when she filed her second amended complaint. I don't know why that peaked so much because it's the 18th, February 18th. Even though she filed a new amended complaint, people still called her a liar, even more so.
Because she changed a lot of her statements.
That's true. That is true.
Because I didn't think that she was a liar initially. Mm-hmm. From my own experience, it's just like I didn't see her as a liar. I just thought she was like a Karen, like you want to make issue of everything. You want to talk to the manager when you can resolve it with the person that's right in front of you, right? So I thought she was more of a Karen than a liar. And then as she changed her statements and then said, "No, I didn't change them," I'm like, "You're a liar! Like we're seeing this real time. Like we can read it. It says here that you didn't change it. I'm comparing these two paragraphs and they are different."
Right. I did also, yeah. I mean, I also noticed like as with the Blake Lively is a liar hashtag, it says the sudden use of these hashtags, like the defamatory things happen after, like the liar stuff comes up after he's accusing her of being a liar. And I'm like, right, but that's because she wasn't making an allegation before, right? Yeah. Like she wasn't, yeah.
Right. And there was no backtracking in her allegations.
Right.
We had seen a little more evidence. And so I think people also it's just easier to say she was a liar than to say, hey, she's kind of manipulating the information, how she presents it, and
right.
to gain this kind of traction with PR. It's like, it's just easier to say she's a liar. So I could see why that hashtag would take off.
Yeah. I'd give anything to know how much they've spent.
Do you think we'll ever know?
They might. I mean, they may, if they ask for attorney's fees at trial, they'll have to say the number.
Ooh.
So, but I don't know if they're going to bring up all the legal fees for everything. If they have an oral argument for that 47.1 thing, they might have the full number of like everything that she has spent. I'd say it's 30 million.
Ooh.
One of somebody I saw this online. Obviously, this could be complete BS, but I saw online that somebody said one of these expert reports cost $500,000. And
they probably have their pricing up.
I mean, they have their billed by the hour. I just don't know how we're getting to the number of hours, but it's not crazy. Let's see. So actually, this is a good question. The judge can't just say subjective, fierce advocacy. Public need to know on what basis Judge Lyman said that. There's got to be a judge book they follow through policies or roadmap. There is. It's case law. It's trying to find a case that is similar enough in fact pattern and to say, is this like this case or does this go beyond this case to a point where it isn't protected? So there's not like a book. I mean, the book is the Constitution, but that's not very specific. So like if you saw Not Actually Golden's video earlier on the AI statements, where typing something into an AI, into ChatGPT is not protected or privileged, even if it was something you were doing for an attorney. Like it's like you're waiving the attorney-client privilege because you're telling the ChatGPT what's going on. So that was the finding. And so that's like, that's a case of first impression. So the judge is saying, you know, if you were telling a third party, if you're telling your friend what you talked about with your lawyer, you'd be waiving privilege. So he decided telling ChatGPT is like telling your friend.
Oh, wow.
Yeah. But that's the roadmap. The roadmap is, do I think it's more or less like another thing? And they just kind of, let's see. There's not a limit on how many witnesses they can call, but they may have a limit on their case. Like he may say we're doing a week, so figure your timing out. But there's no limit technically to how many witnesses. And they could call Ryan Reynolds at trial, even if he wasn't deposed. They can call anyone who wasn't deposed. It does sound like Lively withheld Ryan. So what questions get jurors immediately dismissed? And how many jurors can they get to choose without agreeing? So I'll answer the second part first. You go into a courtroom, they start asking you questions, and the jury gets a certain number of peremptory challenges, which is saying this juror can be removed from the jury. I'm not going to tell you why. I just don't like something they said, right? So, you know, Carol glares at Blake or something, and they're like, I'm sending her home. Gone. I don't like her. I walk in wearing a, you know, I heart the Baha'i faith shirt, and they're like, nope, get out. And they don't have to, actually, I don't think they can do that. They can't do it if you're based on like protected characteristics, but they don't actually have to tell you that that's why they're doing it. So that could come up later, but they get 3 peremptory challenges in civil court. So they just get to send 3 people home, and they don't have to justify it to anyone, theoretically. And other than that, you have to dismiss for cause, which is something like, I know the people, I work in the industry and I've worked with Blake Lively and she's a nightmare. Or I have met Jamie Heath and I'm his next door neighbor. So those kinds of things will get you dismissed. But other than that, you just take what you got. As far as jurors getting immediately dismissed, I mean, if you say you can't be impartial, that's going to be more than likely an issue. But they're really going to press for like, do you think you could set aside a bias if you have one? You know, they're going to, there's not really like a question that's definitely getting you dismissed from jury duty, other than like you saying, I think the cops always tell the truth, or something along those lines. Or I think the cops always lie. And I'm more familiar with criminal stuff, so the civil's not. Yeah, I don't know what they'd say to get this. I guess if you said, you know, I'm on YouTube all the time and I talk about this case, none of us are getting on this jury. If you're in the chat, you're not getting on the jury. So if you were planning a move to New York.
No, probably one of the questions is, have you participated in conversation
Right.
online?
And that actually, if somebody said like, yeah, I follow Yarn and Order and she's talked about this case, that might not get them dismissed.
No way.
Yeah, they might say, well, can you put aside whatever Yarn Girl is saying? And they're like, yeah, I could. Yeah, you know, she mostly just says weird shit about colors, and I don't even know what her whole thing is. So they're like, okay.
Oh, interesting. I thought it was like an automatic.
There's not. Yeah, they don't. I mean, they can rehabilitate, which is where you said something, and they can try and see if they want to get you in. You know, because the other thing is, if somebody says, well, I follow celebrity gossip, or I'm a Swiftie or something, maybe they can be persuaded, right? Maybe if somebody says I'm a Swiftie and I love Taylor and I run a Facebook group that's called I Heart Taylor Swift, both sides might think, well, maybe we can get this juror over there.
Mm-hmm.
I will be there. Don't stop my dream. I won't tell. Let's see. Okay, so let's pull up this New York Times article. Where is it?
I didn't read it all.
That is Deadline.
Just glanced, skimmed.
Here we go. All right, it's short. All right, so we have pivoted from Inside a Hollywood Smear Campaign to Lively v. Baldoni, which is not the name of the case. This irritates the shit out of me. It's not. It's Lively v. Wayfarer. They're the defendant on all the claims.
It's just not so grabby.
And it's also like, why are we forgetting about Jamie Heath if the stuff against him is worse? I mean, I know why, but why? Lively v. Baldoni tests what crosses the line on a steamy movie set. An affectionate slow dance, references to pornography. What rises to harassment on the set of a movie about a sexual relationship that turns violent? By Julia Jacobs. Do you want to read it or should...
Yeah, go for it. No, you go for it.
Okay.
You have it up on the screen.
Okay, so when the legal battle between Blake Lively and Justin Baldoni began raging more than a year ago, footage of the two actors slow dancing on the set of the movie It Ends With Us became a litmus test of sorts. The footage depicted Mr. Baldoni, the movie's director, leaning in to nuzzle and kiss Miss Lively, his co-star and romantic partner in the 2024 film, as they danced at the center of a crowded bar scene. To Miss Lively and her supporters, this was an uncomfortable, unscripted advance and part of a pervasive pattern of sexual harassment on set. To Mr. Baldoni and his defenders, notice supporters versus defenders, just saying, the footage, amounting to a total of about 10 minutes, was proof he had behaved appropriately and realistically in a scene meant to depict a couple falling in love.
Mm-hmm.
So this is that. I have actually never watched this footage.
You haven't?
No.
Interesting. There's like 5 different angles, and you still
I've seen like somebody be like, "Oh, have you seen this?" And it's like I literally have a surrounding like a 360 view of this scene, but I haven't actually watched the video.
You should. Is there a reason why you're not?
I kind of wanted to see what their depositions would say about it, and then I wanted to watch the footage and see if I felt like one of them was more accurate than the other, because the deposition is where you're under oath.
But so, they didn't even spend time asking her on that.
I know. I read all of Baldoni and Heath's depositions.
They didn't even spend any time covering anything.
Yeah. Yeah. I was like, I've read 14 hours of this man's deposition and there's nothing. So all right, once simply fodder for debate on the internet, the footage is now key evidence before the federal judge who will decide whether Miss Lively's claims of harassment, retaliation, and defamation should proceed to trial this spring. At a hearing in the case in January, Judge Louis J. Lyman of Federal District Court in Manhattan made clear he is thinking carefully about the bounds of acceptable behavior in filmmaking, an industry that has undergone a significant cultural shift over the past decade in response to the Me Too movement. Does a director have any ability in that kind of setting to improvise with respect to what the actors are doing, to go off script a little bit? Judge Lyman asked during the hearing. Your Honor, an actor can improvise with consent, and that is the issue here, replied Ezra Hudson, one of Miss Lively's lawyers.
Pause. Consent is the freaking contract.
I mean...
And the nudity writer, right? That's what you sign off on.
Can you sign over consent in a contract?
that is what you're signing on for. Yes, like I think you can. It says there you can show my body part that I would be able to show in a bikini. You can do that. That is acceptable. Anything further than that would require my prior approval.
But this isn't about nudity. This is about whether he can touch her.
But that's the acting contract, right? Like she is playing a role. She is playing a role. And that's where the contract comes into place.
Well, that's Wayfarer's argument. Hudson's argument is that it would be the same as like an interpersonal relationship, where if somebody says "Don't touch me," you can't touch them.
Yeah. So then, how could we make this movie?
That's what Lyman's saying.
Like, how can we make this movie? Like, it sounds like you need to go to a different job, like radio hosting, where no one ever has to you. You know, like. It's only voice, like, voice recordings. Or
like start a YouTube channel. Trust me, no one wants to touch you now. Does Blake consent to be directed? Does Blake consent to do anything? And I mean, this is precisely the issue, Pam. Agreeing to be in a creative environment is consent. I mean, okay, let's devil's advocate here a little bit. Because she has a nudity rider, but they can't negotiate the nudity rider after she signed it. They can't say in the moment, like if she was to say, actually, I'm okay doing this scene naked, you know, even though my nudity writer says bikini, they still have to get a new nudity writer. They can't just take her word for it, you know? I don't know. I mean, there's
well, it doesn't with approval of the actor and loan out company. So that's what I'm saying. It's like that's exactly what the judge said, was like, then there would be no use for contracts.
Right.
There would be no use for contracts. And then every actor is going to be in here for a Title VII. Right.
That is, yeah. And the other part of that is, if they don't have Title VII, then how do they sue? Right. Could they, I guess they could sue for assault. But that'd be a hard sell, I think.
I mean, I think that's what they were doing at the hearing, that they posed all these actions as assault.
Yeah. So, I mean, yeah. So I think Ezra is saying it's basically as though you have to get consistent, ongoing consent in the moment. And yeah, this is what Lyman is kind of saying, right? Like, how are we going to do that? Because you can't get the consent like verbally out loud in the moment because you're filming. I mean, you know, maybe Jess Khaleesi brings up an interesting point, and I know you didn't say this, but I'm going to say it. Maybe Blake Lively was planted by the AI industry to create, hear me out, let me cook, as the kids say, to create a bunch of these ethical concerns so that somebody says, fuck it, let's just use AI. That's 4D chess. That's 4D mahjong.
But the thing is, in her contract, she was like, you can't even use my likeness in a AI simulated way.
No, she doesn't. Yeah, she's not an AI actor. She just gets the kickback from the AI companies.
No, she in her nudity writer, it says they cannot use an AI image of her to do anything that she's already said no to.
No, so, I mean, she's getting paid by AI companies to bring this lawsuit. So that way she makes many issues of consent that way they're like, you know what, we have to start using AI because we can't get consent from all the actors in the way that the law requires.
And it would be continuous consent, like in every scene, every day. Like she just didn't feel like acting. She should have just called in. She should have negotiated like days that she could take off and say, I just don't feel like I'm going to give any consent today, you know?
Yeah, she could say, I'm not doing any consent today. And that's the 4D mahjong.
I need to go to another concert. You know, let me think about it there. And, you know, and Kai's come in early because you guys want to come early. Not because I want to go to a concert, but because you guys want to work earlier.
Right. Mama Panda, does that tie in back with that AI PR firm that Rolling Stone used about Taylor Swift? See, this is what I mean. This is why they're going to quote this in the trial. They're going to be like, can you believe these content creators? This is we're figuring this out. Finally, we've cracked it. All right. So Miss Hudson outlined a protocol that has been broadly applied across Hollywood. Brokered by an intimacy coordinator, the process requires that in advance of filming, actors be given the opportunity to review and approve scenes. involving kissing or other kinds of physical touch. Mr. Baldoni's team has argued that this encounter, as well as others Miss Lively cites in her suits, are nowhere close to violations of sexual harassment law. We go to federal court when someone leans forward, when someone nuzzles. I like how he says that. We're in court because of nuzzling, asked Jonathan Bach, one of Mr. Baldoni's lawyers at the hearing. The debate is but part of the sprawling civil case filed by Miss Lively against Mr. Baldoni, his production company, and his associates. They are accused in court papers of unleashing a retaliatory campaign against her, one that the suit says was waged by planting and amplifying items on social media and in the tabloid press. Remember when this was bots? Get Megan on the phone. She's got thousands of pages of documentation about the bots. What's her name? Julia? Julia, where's Megan?
I know, they should.
I want Megan on the phone. Megan's got the bot info.
What does it say?
It says, one the suit says was waged by planting and amplifying items on social media and in the tabloid press to destroy the actress's reputation and to discredit her claims of sexual harassment. I thought this was a bot campaign.
Yeah.
Where's my digital army? Where's my Judd Wallace? Megan, we miss you. Come back. All right. For those in the film industry, the judge's decision is likely to send a strong signal at a time when Hollywood is still adjusting to protocols and sensibilities that were popularized during the Me Too movement. Intimacy coordinators are now widespread, as are nudity writers that outline how much skin and simulated sex are on the table. Miss Lively's nudity writer specified that she would show only as much skin as it could be seen in a, quote, reasonably modest two-piece bikini, and she would have the right to approve any changes to intimate scenes in writing. But as public attitudes may have changed, the standard of sexual harassment law has not. The challenge for the courts in recent years has been mapping it onto a surge of high-profile cases, some of which stem from the entertainment industry, where sensuality, even vulgarity, can be part of the product. Let's see. Oh, I've been curious about this case. I don't know anything about it, but for example, background dancers who formerly worked for the singer Lizzo objected in a lawsuit to being brought to a performance that included nude dancers. Lizzo's lawyers have argued that outings such as this one were part of her creative process. Mr. Baldoni, whose own suit against Miss Lively was dismissed last year, contends she used false harassment complaints to seize control of the film. His lawyers say his crisis management efforts were aimed only at protecting his reputation in 2024, where he began to feel that he had been unfairly sidelined from the movie's premiere. They say there is no evidence that Mr. Baldoni or his associates promoted any false story about Miss Lively. Settlement talks last week did not yield an agreement, so unless the judge dismisses the case in the coming days, it appears to be heading toward a trial in May. Such a trial would draw enormous attention as dueling Hollywood PR machines and high-profile lawyers debate a case involving matters of sex, celebrity, and unsealed text messages from Taylor Swift and others. The movie It Ends With Us was an adaptation of a Colleen Hoover novel about a relationship devastated by domestic violence. Miss Lively, who portrayed the woman who suffered the abuse, has said the film itself became a hostile work environment. She said in court papers that Mr. Baldoni informed her he was circumcised during a conversation about parenting decisions and had once been addicted to pornography. She says he described one of her outfits on set as sexy and hot, apologized for his remarks, only to then joke that he had missed the sexual harassment training. Remember at the beginning of this when it was like he discussed his genitals?
Mm-hmm.
And now it's like he was circumcised in a conversation about parenting decisions.
I was listening to Bocce's like one of her old videos. I was watching it and she was like, remember when I called that out and said, if I was Blake Lively and I'm trying to make something so sinister, like so innocuous seem sinister, what would I be talking about when someone says, I'm talking about this? And then she's like, I think it's either circumcision or vasectomy. She's like, I don't think he was talking about it in any other way. So she had called it months before it actually came out.
We've literally found the one man who has never made a joke about how big his dick is. I mean, actually, let me go check on our poll because now I have another idea for another poll. All right. So I've got 29 votes. Yes, 84% find Brian Friedman credible. 86%. All right. Let's see. Okay. So, yeah, I mean, this is the only guy that I've never heard. Let's see. I mean, well, we know it is Mama Panda when she says, which just shows how big it actually is. We know that from Ryan because
Just
we know
Khaleesi said she voted wrong, guys. I voted wrong too.
that's exactly why I do it though. That's why I always put no first because everybody's just gonna be like, I'm gonna click the first one. Um, but the thing is, we do know because Ryan Reynolds has it on his mind, and he decided that when he was doing a depiction of Nice Pool, he needed to draw our attention to it because it's just something he's thinking about for reasons. All right.
Why is he even thinking about that? Weirdo.
That's a whole other live. Okay, so we need Alicia. We need Alicia in here.
Let's say we speculate wildly on a Friday night.
I do have here we go. Wait. I'm not a lawyer. This is all allegedly for entertainment purposes. Please don't subpoena me. So
The last part is the important part. Please don't subpoena me.
Please don't subpoena me. Let's see. Okay. So Miss Lively's suit also says Jamie Heath, the chief executive of Mr. Baldoni's production company, abruptly showed her a video that he described as footage of his wife giving birth. The suit also accused him of staring at her when she was topless in her makeup trailer after she had asked him to keep his back turned. I have videos on both of these, just so you guys know. I drew a diagram and everything.
Oh, she drew her. Yeah, I was gonna say she drew a diagram, guys. You need to go see it.
Yeah, this might help you guys understand what her complaint is because I think it actually makes more sense when I drew it out. Okay, so Mr. Heath said the video actually depicted his wife after the baby had been born and that he was asked to show it in the context of planning a scene for the movie. Any glimpse of Miss Lively in the makeup trailer, his lawyers have said, was clearly inadvertent. Lawyers for Mr. Baldoni and Wayfarer, his production company, have argued that the episodes amount to no more than miscommunications and awkward comments. They say Miss Lively's concerns were easily resolved. After Mr. Baldoni and Mr. Heath were made aware of them, no other complaints about their behavior arose. Such passing, sporadic comments, while perhaps ill-advised, are not outrageously offensive in an environment where professionals are working closely together to make a deliberately sexually charged film, his lawyers wrote in court papers. Mr. Baldoni's lawyers have cited a landmark case for the entertainment industry, a sexual harassment suit filed in the early 2000s by a writer's assistant on the sitcom Friends. The assistant describes the show's writer's room as replete with vulgarity, including graphic discussions of the writer's own sexual experiences. The California Supreme Court found against the plaintiff, ruling that on a sitcom with sexual innuendo in its scripts, lewd conversation in the writer's room reflected the creative process at work. The court also found that the vulgar comments were not targeted at the assistant because of her gender, a legal standard under harassment law that is central to whether Miss Lively's sexual harassment claims will proceed. I just want to say this article is pretty good. Like they haven't really gotten anything super wrong, I think.
Except small little biases, right?
Like they're kind of they're still on her side, but they're being a little bit more they're legally informed. So Mr. Baldoni's lawyers have argued the behavior Miss Lively has cited had nothing to do with her gender and everything to do with portraying the steamy and turbulent romance central to the film. But Miss Lively's team has cited the accounts of other women to suggest there was gender animus on the set that made others feel uncomfortable. I wonder if they would agree. Jenny Slate, an actress in the film, said in her deposition that Mr. Baldoni had made an unwanted comment about her outfit being sexy. Another actress, Isabella Ferrer, said in a deposition she felt uncomfortable when Mr. Baldoni commented, "I know I'm not supposed to say this, but that was hot," after they filmed a scene about her character having sex for the first time. Let's see. Experts said that not every discomforting experience at the workplace necessarily supports a legal harassment claim, which requires that the behavior rises to the level of severe or pervasive. One way to think of this case is a clash between broader cultural perceptions of harassment post-Me Too movement, said Russell Robinson, a law professor at the University of California, Berkeley, who has expertise in anti-discrimination law, where I think a lot of people, especially women, would read the allegations and say that's inappropriate. But I think for courts, he said, the standard for harassment is much more demanding than the general public perception of what's appropriate or inappropriate. Another issue is likely to be whether the discussions of sexuality on set were related to the work of making the movie or gratuitous. You can consent to being in a work environment where the discussion or the work is focused on sexually explicit topics, said Nicole Page, a lawyer with expertise in discrimination cases. But that doesn't mean you consent to have someone in the room turn to you and ask you your personal sexual preferences.
What
which
if
is why
somebody
it's
volunteers that information?
also, where is she saying that happened?
Well, I think she volunteered that she did not watch.
Oh, okay.
I think but she volunteered that information. No one asked her. She volunteered.
Well, here's what it says. Miss Lively's suit says, for example, that while proposing a scene in which the two lead characters simulated simultaneous orgasm, Mr. Baldoni told her that he and his wife climaxed at the same time and asked if she and her husband, Ryan Reynolds, did the same. I didn't think he asked. I thought she said, yeah.
She said, I would be mortified if that ever happened to me. So we just know that she has never had a no without Ryan getting one.
It's interesting, too. I didn't realize this. Mr. Baldoni said in a deposition that he did not recall a discussion with Miss Lively in which that had been discussed. Did he really?
That he did not recall.
He did not. I thought he agreed that happened. Maybe not.
I don't remember this.
Yeah. Huh. The setting, it's because I praised her.
I think he did say that she volunteered that information.
Yeah, I thought he did say, I don't think he said he didn't recall. I feel like I praised Julia, and now the article is bad.
You're like, it's starting to turn.
Right. Okay. Let's see. The setting of conversations depicted as objectionable are part of what judges ponder. In one of several lawsuits brought by women in the Real Housewives franchise, Leah McSweeney, a cast member, objected that the host of a reunion special, Andy Cohen, had asked about her sexual experiences with other women, among other complaints. In dismissing the gender discrimination claims, Judge Lyman noted that if the conduct she described had occurred on the factory floor or in the executive suite, it would rise to a valid harassment claim. But this was reality television, the judge said, and the cast members were well aware of the agitating role that Mr. Cohen had long played as moderator of the reunions. So that is Lyman's view, just to prepare you guys. As the two sides in the Lively case await Judge Lyman's decision, the trial in the court of public opinion is already well underway on social media, where users have dissected a trove of evidence that has been unsealed over the past month. Reddit threads analyze unsealed text messages. Podcasters parse emails surrounding Mr. Baldoni's damage control efforts. Armchair legal analysts on TikTok and YouTube pick apart footage from the set and this New York Times article. Underlying the social media debate and legal sparring is a battle of wills between two wealthy Hollywood celebrities and their teams of zealous advocates. Central to that battle is the question of who had more power during their ill-fated collaboration. Was it Mr. Baldoni, who directed the film, made by a production company he co-founded, or was it Miss Lively, who Mr. Baldoni has accused of leveraging powerful allies such as Mr. Reynolds and Miss Swift to increase her influence over the film? You can tell there's a PR battle happening alongside the legal arguments, Professor Robinson said. Each side wants to portray their client as a victim.
Well, they need not read far. They should have just attached the PGA letter.
So, I criticized it, but I think it's certainly more balanced than the original article, right?
Right, yeah.
Let's see. Yeah, what do you guys think in the comments?
Anybody has any questions?
Any thoughts? I will say, I said this at the beginning and I'm saying it again. I think that Melissa Nathan's PR win in all of this is getting this from the original, smear campaign to this, right? It's a celebrity feud. TMZ is covering it, That's
a really good observation, Sarah. Like that is a huge one.
Yeah, getting it from this one-sided thing where it's like he's evil to TMZ are doing polls on who wore it better.
Mm-hmm. And then it's just gossip.
Yeah, it's just gossip. It's, Deadline is, let's see what the comments say, actually. Justin will have an enormous fan base after this. She's been an actual nightmare. Don't settle. They should settle this with a claymation celebrity death match. Let's see.
It's so unserious.
But that's what I mean. That's Melissa Nathan, isn't it? Right? Because people aren't taking it seriously.
Are those the only comments?
Yeah, those are the only ones that I downloaded. balanced-ish, but still attacks content creators and lawyers who are doing the New York Times job. Yeah.
All right, guys. I think I have some more comments. I screenshotted a bunch of them. All right, let me read this.
Are you able to share? I don't know how to use StreamYard.
Okay, let me see. Okay, can you add it to the stage?
Yes.
Rachel, what do you mean? Can we discuss the shift in the smear campaign, how it's not on Melissa Nathan or Brian Friedman? What do you mean?
Oh, I think she means how it's now on Melissa Friedman or Melissa. Yeah, can we discuss the shift in the smear campaign to going after Melissa and Brian Friedman? I mean, it tells me they don't have anything. It's all just guilt by association.
Yeah, I was like, I don't think so. I think they're just gonna. I think it's just the association. Yeah, that they're just trying to reach.
Right. Let's see.
Okay, so can you guys see my screen or no? Like, can you see it or no?
I can see it. If you drag it, does it get bigger?
Like, no, that's as big as it gets.
Okay.
Can you guys in the comments read it? I can change it to a different screen. This screen is just easier.
I mean, if you're going to read them, it's fine, I think.
Okay. So the first one says, I definitely do not want this case to be seen as standard for handling workplace harassment. That is a real issue. I do not know this is because a lot of it seems to be celebrity ego driven. It has generated a lot of attention online, but this is Aesop's fable with a clear moral conclusion. For standard for handling workplace harassment, I think that there is a process and these people try to go around it to achieve different goals. And that's why it wasn't handled like you typically handle any kind of complaint. Other than it was resolved, like that is what you want when you bring a complaint, for the thing to be resolved, and to dead the issue and to move on. And I think that I kind of find it a little bit like ironic that the girls kept saying like, why don't they just move on, when they in reality never moved on. They kept talking about the same two instances over and over and over and just trying to make more of it. And I'm just like, you want them to move on, but you never moved on. So anyways, this one, I think the article missed the main issue: power in the workplace of the employers to subject employees to overt and repeated sexual abuse. This person's not even informed, because this has nothing to do with abuse. This flagrant ability of employers to repeatedly insert, yes, you read that right, their sexist, offensive, and demeaning behavior and language at work degrades the workplace itself and their predominantly female employees, regardless of the specific cultural / business mores of the industry, regardless of the level of fame and money of the employees. What about regarding the topic at hand? What about regarding the themes of the movie?
Right.
Or that, or do we just regardless of everything, Cal? Is it offensive to the readers of the NYT to flippantly frame this lawsuit as a tiff between dueling PR firms? Oh, there's your comment, Sarah.
There you go.
Yeah, if anything, Mr. Baldoni and his team's repeated offensive behavior mirrors that the actress Salma Hayek vividly described dealings with Harvey Weinstein during her efforts to film / act in Frida. Let women work. If you wouldn't say something out loud or in public or to your own mother, keep it to yourself in the workplace.
Yeah, like don't make a joke about how your bedroom in the apartment is too small for sex. I don't think you should say that in a workplace.
But that's what I'm saying. Like, some people are going to mess up. What do you? Obviously, we hope that you never encounter this.
Right.
Like, we hope that Slate never said this, but you said it. So what do? Like, you apologize, like what she did. I apologize. Can we move on past this? And then you do. And I just think, like, here it was like, no, you're going to wear the scarlet letter forever, and you're going to tell everyone that you're a fraud because you messed up and you are not who I think you are. So I need you to tell the world that. And it's like,
yeah, and I agree. I think that people who are saying things like this Cal person, I think that they do not hold themselves to that standard.
yeah, it was
like
what do you,
I don't.
What do you expect? You're not gonna fight. Like, you're gonna say inappropriate things. You're gonna do this. What do you expect someone to do?
Right.
Anyways, okay, so it strikes me as odd that the women and a man to choose to use their bodies to profit from an audience in a film emphasizing sexual issue now seek to profit from each other's actions while making the movie. I appreciate a woman's desire and need to protect herself from unwanted sexually loaded speech and actions, but it is unreasonable to expect the film involving sex and sexual content and will not make the actors uncomfortable at times. Do you know what? Someone argued with me in the comments and said, only because someone is making a movie about murder doesn't mean that the actor has to see how murder happens. And I'm like, how do you think they make the murder realistic? So someone has to watch it. Like, someone has to inform themselves. Someone has to educate themselves about, like, a death and, like, what happens if a vein gets hit, or, like, in order to make it realistic and for it to translate in the movies, someone has to watch this.
Right.
And she's like, yeah, but the actor doesn't have to be subjected to it. So then pick another movie.
Oh. Yeah, you don't have to be in movies that do certain topics.
Yeah, you can be in a PBS film. You'll be fine, you know? And so perhaps the answer is not to place yourself in a sexually charged environment to profit. To me, filing a lawsuit for money damages because you felt discomfort in connection a choice to make money creating sexually related art is a slippery slope. I guess I would see it differently if the plaintiff was donating the profits from a film or the lawsuit to a related cause. As it stands now, it all seems something is off. All roads lead to money. And then people argue with that person. Interesting that this is in front of Judge Lyman. His brother is also a well-known director. Oh yeah, and somebody cheated on his set, so they're familiar with that.
Right. Can you imagine? I have said this before, but half of Hollywood wouldn't exist if we had actual HR departments on film sets. Guys, if you've never had a regular job, you're not allowed to sleep with your coworkers. So
yeah, that's the same.
And half of that you guys don't want the rules to apply. And then, like, half of Hollywood, like, their parents met on a film set, you know? Imagine if you could get fired for that.
Yeah, I mean, I think most of these comments, some people are just not educated enough about it. Even the kind of dumb comments like this guy saying, "Oh, if you don't want to be complimented on the dress, don't wear it." Sir, educate yourself before you come.
It's like that isn't really the point. It's not.
Yeah, I was like, that's not the point, sir.
You know.
Oh, someone else noting the industry connection.
I do agree with Eliza's comment here. This lawsuit exemplifies the power of aggressive PR teams to direct the narrative. Yeah. Like I said, I mean, even though it's since the lawsuit, I still think Melissa Nathan's directed the narrative, right? Or at least partially. The lawsuit is more entertaining than this mess that was passed off as a film.
It sure is. By arguing with someone. Went to the library, picked up a copy. I don't know about this guy. The Gilded Age. Let's see. So, comment is funny. This comment is funny. It says, over the months, I have read numerous articles on this case. And all of this time, I could not tell who Blake Lively or who Justin Baldoni or who was Justin Baldoni. I guess all the articles, authors all assumed we know celebrities. Thank you, NYT, for finally including a photo indicating who is who. It was opposite of what I imagined. Blake Lively is female and Justin Baldoni is a man.
I guess I never really thought about that, but yeah, I guess Blake is a male name.
They thought this was Justine
Baldoni and Blake Lively.
That is hilarious. I wish they would have wrote a little bit more. I wanted to know what they thought.
Let's see.
Intimacy advisors for kissing scenes. Beyond that, what intimacy? In American movies, women never take off their bra, and there's always a magic bedsheet that keeps them covered. I don't know what that means. Oh, you know what? What was I gonna say? You know what? I just had a thought, and I forgot. I forgot about it. Yeah, but most of these comments are not good, guys.
Let's just go to our poll really quick. I'm just gonna take this down for a second. Just put the poll up. So I did ask our live chat. Have you ever done something that could possibly be an HR issue, but you handled it without HR? The options I gave were no, yes, and what are you, a cop? And that was our lead answer. What are you, a cop? But 31% said that they have handled an HR issue that they privately without necessarily going to HR. So there we go.
Guys, we got your guys' names and we're giving this to your HR department.
I literally have Nick Shapiro. Like I have the chat open right now. I'm telling Nick Shapiro everything. Let's see. Okay, how do I?
That is hilarious.
Let's see. Well, if only hospitals would heed that advice. It's a regular Peyton Place. That is an old school reference. That is such an old school reference.
Why?
Peyton, have you ever seen Peyton Place?
No.
Oh, it is a soap opera, and it's like it's from the 60s, and it's like this town where like everything happens and everybody's having an affair and there's drama and backstabbing and gossip. But yeah, healthcare is a thing. Let's see. Oh, I think I closed out your comments and now I can't put them back.
Oh, I don't know how to do that. I mean, I don't know.
Oh,
it's okay. I can see them. I'll share a comment in there. Yeah.
Let's see.
Yeah, someone said in here like they turned a Slate's S joke into Baldoni being creepy. Yeah, like Jenny Slate said this, and all of a sudden, because he's trying to make the moment less awkward, he's the bad guy. I think that is what, in my opinion, makes someone seem like they had an agenda, to get an ultimate result from this.
Right.
I don't want you to like this person. It suits me that you don't. I like to alienate the affection.
Let's see. Let me see if I have this. Upload.
Thank you everyone for watching, liking,
doing the YouTube things. Yes.
Yeah, doing the YouTube things.
I'm very bad at YouTube. Let's see. Okay, I did put this together. I've never done anything with this, but this might be helpful. You might have heard in litigation somebody say Title VII isn't a civility code, and I had gotten ready to do a video a while back on this, but I never did. But this
Title
is the
VII
lawsuit.
is what? What
Title
code?
VII isn't a civility code, like civil,
Okay.
like dictating behavior.
Okay.
So this is the case. It's Ahern v. Shinseki, and it's from it's a federal court case from 2010. So what happened is, this is from the First Circuit. This is a different circuit than Judge Lyman, but this is kind of the case law that they're referring to. So it's an appellate case. The plaintiff, Ahern, is appealing a summary judgment that was found in favor of the employer. She was alleging that basically the employer did all sorts of things that constituted gender discrimination and that he retaliated against her. And it was dismissed on a motion for summary judgment. So there's some excerpts in here that I think are helpful for like why Wayfarer is bringing this up. And employers often bring this case up. So I won't go too much into this, but Eileen Ahern and some radiology technicians were working for the VA, and the defendant is Eric Shinseki. He isn't actually the person who did this. He was the Secretary for Veterans Affairs, and he's the head of the VA. So these women worked at the VA as radiology technicians. They're suing the VA because they are saying that this administrative officer, Khatib, who is their male boss, was essentially an asshole. Right. So they're suing the VA because the VA is the employer. So you don't have a private right of action. So they said he created a hostile work environment. And the way that it's basically he's an asshole, right? He's telling them off. He is interfering with their training. He reassigned their jobs. He was changing the schedules without much notice. He was not yelling at them, but he was very irritable, and he was like, saying negative things to them when they were talking about this. And I can link this in the comments here, but basically the judge in this case said they couldn't prove that there was like a discriminatory hiring decision, that getting a negative evaluation or somebody being kind of grumpy or somebody being a jerk or rearranging your schedule or moving into a different department isn't an adverse employment action. And reassigning people or on-call scheduling wasn't linked to any sort of protected activity. But what they do say in this is, the final analysis, the claim falls on the merits. Title VII does not create a general civility code for the workplace. Consequently, a plaintiff which seeks to withstand summary judgment on a claim of constructive discharge must point to evidence in the record that as a result of discrimination, her working conditions were so difficult or unpleasant that a reasonable person in her shoes would have felt compelled to resign.
I mean, if she didn't feel compelled to resign, isn't that enough?
I mean, that's the thing. And this is a funny appellate decision because they spend about 20 pages saying, yeah, he's an asshole. Like, the court finds that he's a jackass, but this isn't.
And also, Slate didn't feel compelled to resign. Alex Sachs didn't feel compelled to resign. So how did it impact their work so much that they all testified under oath?
And Slate didn't even file an HR complaint. She was asked by Alex Sachs, do you want to go to HR? And she said no.
Yeah, like, that's enough.
Yeah, I feel like it's been handled.
And then later on in her testimony, she's like, well, I don't think it was handled, but whatever.
Like, it is what it is. She's like, I would very much like to be excluded from this narrative.
I don't get it. I really don't. I don't understand them.
They went to a lawyer and they said, what can I do? What can I build out of this?
Mm-hmm.
And
is there kind of any other kind of thoughts on the either settlement or the NYT that you feel we should touch on?
What do you think about Ryan not going to the settlement?
Wait, I am asking for consent to touch on those topics.
I have to consent every minute, so every minute I'm just gonna, yeah. Because
how was I think that those are my thoughts. I think Baldoni stuff is going to be thrown out. I think that's going to be interesting what they do with the PR of it. I think that the judge made very much a lot of emphasis during oral arguments on the distinction of director, and both of his incidents were as director and actor. And even one instance, it really doesn't. The birth scene. They have changed their stance. The Lively team from she wasn't offered a cover-up the whole time. At
Mhm.
the court, they said, well, sometimes she had a cover and sometimes she didn't.
Right.
Sometimes someone gave her a cover, sometimes she didn't. So I think, I think the proof is in the pudding. If there was video evidence of the things that she claims, like that happened during acting, like the lip biting scene, the judge asked about the lip biting scene. And they were like, oh, no, that's not what we're talking about. We're talking about a kiss on the forehead. I mean, they never specified it was the forehead. They just said, oh, no, it was the improv kiss, the one on the forehead.
Right.
They never went back to the judge and said, oh, and the biting one, yeah, that's bad. And we don't get footage of it. And we don't. So if it lingered too long, if the bite was there, because it's obviously on footage, they did it for the scene and they didn't turn it over. I just think that it's not going to be there.
Yeah.
So
yeah, I mean, I don't know. I'd be crazy if the Baldoni stuff got dismissed and the Heath stuff went ahead, just from a PR perspective, because everybody's going to be like, "Who's this guy?"
yeah, that's what I'm saying. Like, I think that will be an interesting thing. I mean, I don't know. I'm not an attorney. I'm not in the legal field. It's just from pattern recognition in the questions, I really heavily started thinking, because he also said to Ezra's question, she was like, oh, do they have any liberties? And she answered, yes, they do. And he was like, oh, I'm glad you said that. So I wonder if he's gonna use what she said as basis for something that he was already thinking, because he's like, I'm glad you said that, because now I'm going to include it in my order.
You guys said that there were liberties, and I find that these are all within the realm of what directors can do.
Yes, because he said, I'm glad you said that. And that real, I mean, I think most of the oral arguments, they were really harsh and really harder on Wayfarer parties. At least that's how it felt in the court. And in the answers, like, you could just tell, like, live, it just felt much harsher on them than it did on, and Blake Lively's attorneys seemed to, like, just respond in their quick to their thinking, even though I think it was irrational in my opinion. Some of their stances were like, oh, telling the press is protected activity. Like, I don't know how they said that with a straight face,
right?
But they did, and they responded like this, like, yes, it is, like, confidently, not like shakily, like, let me think before I answer.
Right.
So, just like, so I mean, I don't know. So, and guys, I'll be putting a page on the website about hearings. It'll be hearings. I'll just title it hearings. I'm going to add all the transcripts for the hearings all in one place. I think that'll be helpful to everyone once they're all out in Court Listener.
I think if it goes to trial, I think docket updates is going to crash. I think everybody's going to flood docket updates and be like, all right, now I need to know what's going on. I mean, yeah.
After, I was like, I think CJ was the one that had told me, like, after they start prepping for, like, actual trial, she's like, you need to have it up and, like, all the stuff you want up and running, because people will need a place to see this. That's why this timeline piece is so important to me. It's already crashing on me now because it's so large. I'm going to find a way to see if I can make it smaller, or hopefully it functions the right way once it's live.
Remember when you called me and said, I'm making a website? Like, and I remember you said, don't tell anybody yet, but I'm making a website. And you showed it to, was I the first person you showed it to?
Yeah. Well, other than my husband. Yeah.
Yeah. I still remember that. I still remember you like, can I call you? And I'm like, yeah, like, what's going on? And you're like, I made a website. And I'm like, a website? What? A website for what?
You actually gave me a lot of confidence to actually share it, because I don't think I would have had the confidence. I was like, I don't think I would have had the confidence to talk about it as openly, you know.
Right.
Yeah, so I really appreciate you for that. And
I just look how far we've come.
this is too
Like,
much.
remember both of us being like, I've never like talked on the internet about anything. Like,
I think you hadn't even shown your face yet.
yeah, like
And
I'd never shown my face.
and then
And you
one
were
time you're
like,
like, I'm gonna do it. I'm gonna go live. I just need to talk about
I just like, should I go live on TikTok? And you're like, I have a website. And I'm like, what are we doing with this? Like, what do we do?
Yeah, no, I really appreciate the community that we built and the connections that we've made, and Sarah's support, and all, you know, Bocce, Ellsridge, everyone. I think I didn't expect to be met with such openness, I think. So having you all is huge. Actually, it was one commenter that said, "Do it." I was like, "I'm this close to doing a website," and they were like, "Do it,
do it."
Yeah. Maybe the smear campaign is the friends.
Maybe the real smear campaign of the friends we made along the way.
It's the friends that we've made along the way. So yeah, guys. So you know, I'd love to put out more content right now. I love consuming. I love playing your guys' videos, like Sarah's, Ellsridge, Bocce's, Without a Crystal Ball, Kirsty Flaw, David. I play a bunch of them while I'm doing the timeline.
Mm-hmm.
But I'm telling you, like I almost had a crash on myself doing this timeline, but it's giving me a ton of color, and some of this stuff like I didn't review as deeply, but I'm being forced to like read this as I'm translating it over into the website. I'm also finding that a lot of messages are way more connected than I thought they were. So like there's bits and pieces that we've gotten here and gotten over here, and it turns out like they were the same conversation. When you add so much color, it clears up a lot of things. Like, for example, when Brian Friedman did the website and said, like, look at all the excluded text, guys, that was only a portion of the excluded text. I have them all now together, and the way that they made those text messages seem like they were way worse than they were. When you get the whole thread, you're like, they're talking about this, they're not talking about that,
right?
And it's way less. And then I'm also thinking this may be an ad that I do or not do, like an additional, meaning something that I add to the website. But I did it with one article where I posted like within the text messages and the timeline when the article went live, when the article was. And
yes, I saw something. I saw that. Yeah.
Oh, you did?
Yes, there was something you posted where it was like, here's when the tweets were, or something like tweets were happening, wasn't it?
Was it? No, I don't remember. I haven't posted about it yet.
Oh, okay. Maybe I saw something where somebody was like, here's what, maybe it was Reddit then, where somebody said like, here's when this article went live and here were the text messages
that followed it.
Yes.
And some of this stuff is like, there's like, these are there's no way that these were part of the smear, you know, or part of the way that she made him seem. It's like they were part of the smear, and it's like, no. And as a matter of fact, most text messages that we get are from August, like 8 to 14, maybe some of them in 18 or 19, and December to February 22nd.
Mm-hmm.
So I'm like, there's no way all of these articles in August, September, October, whatever that she brought up. So I'm leaving that to the last thing to do, because I'm like, I really need to get the timeline out.
Yeah.
That's the most important thing. I can always add those later. But I'm leaving everything after December as a last thing that I do. Like, we want to know what happened when the
August. Yeah. August is like the priority.
Yeah. So it was like, I'm leaving all that stuff. There's like 20 documents I've set aside. Like, I'm not going to worry to transcribe these right now. I'm going to put them aside to do later. So I think you guys will really like it. Oh, Christina, thank you so much for that comment. That I appreciate it. Yeah, this feels more like a side hustle. This feels like my main hustle, and now my job has become my side hustle.
Your job is just that thing you do to get more money for the website.
I'm just like, you know what? I need to hustle harder. But I really need to get this timeline out. I think I'm hustling hard on it. Some of the text messages that we get span over 2 different days, and you think like they're all together.
Mm.
So that's why when I see other timelines and they're just like, oh, here's where this goes, like, no, I'm sorry, but if you don't take it apart as like this happened at 1 p.m. and here are all the other 1 p.m. text messages that happen, it just doesn't. It does hit different.
I did see like Bocce was doing a thing where she was reading she'd put all the text messages in order, and you could see like minute to minute what people are talking about. And it's fascinating because it's like Melissa Nathan is like in one conversation saying, what the fuck is Stephanie doing? And then she's like texting Stephanie or somebody being like, what are you doing? Like, it's, yeah.
So my timeline is like that. Like, there's not a text message where it's like at 3:21, let's just say Melissa sent this message, but also she sent this one, because it's not possible. So it's like 3:21, she sends this, 3:23, there's this message. And like,
yeah.
It's kind of cool.
Yeah, have you seen this the Asshole Media timeline?
Yeah. Popcorn Planet sent it to me, and I was like, oh, I like it. I didn't do a deep dive. I didn't look at everything. I just overview, scrolled through it. It's kind of cool.
Did you see that? Is it like Blakestein files?
I love that. Yeah.
If you guys haven't seen this, I'm gonna pull it up because I think this is like,
it was crashing on me so often though, so it was really hard to look at it.
It's on mobile, and I think it works really well on mobile because what it does is like if you click on the text message, and I don't know if it will do this in the browser.
Really cool, guys. You guys should check it out.
I would Google it because it's not like BlakesteinFiles.com. It's like it's got its own address. I don't know if it will load. Yeah, it's not going to load. But
have we compared timelines? No, I haven't compared to anyone's. I have looked at A-Hole Media's stuff. I've looked at their stuff, just like scrolled through it. I haven't really done a deep dive on it. I looked at Blakestein Files, which is what Sarah just showed us. Sarah shared that one with me. And there's one more. Who did another one?
Katie had one.
Katie. I haven't looked at Katie's, but I did see her video on it.
Yeah.
And her video, it just shows like the court dockets and the dates. Like,
yes.
Like August 8th, this is the court docket it's on. And again, me doing it myself, I'm noticing how important it is to actually split it from just this docket. For example, there's stuff that we get in docket number 1, right, which is Blake Lively's complaint.
Mm-hmm.
And so if I say, oh, on August 8th, I got, is docket number 1, docket number this, and docket number, then great, you can look at that. But the way that I'm going about it, it's like docket number 1 at 10 a.m. this happened. Right following that at 10:10, and docket number 84. We see other parts of the conversation right below it. And then in docket 963, there's actually a continuation of that conversation in there. And what I started doing is, at first I was just like putting the whole chat, like let's say it's August 8th. I'm going to put August 8th was a Thursday. Bocce, you'll get that reference. August 8th. And you say, just put the whole chat, because August 8th it happened between 9 a.m. in the morning to all the way to 11:59. Okay. At first I was doing that, but some of the other conversations were happening in between. So I had to split them up, and then I have to link those conversations so that in case it's useful to you guys, that you guys can say, well, where do I continue this conversation? So I included internal links that you jump to that conversation if you don't want to know, like side conversations that were happening.
Yeah.
So it's not like anybody else's timeline. It really isn't. Not to toot my own horn. What I'm getting at is that what I think would be helpful is for people to see the actual timeline. The only one big issue that I've run into is that some of these documents, I am able to decipher what time they were done, either with other documents, because let's say something appeared in docket number 1.
Mm-hmm.
I'm going through each and every docket, guys. And if that same message appeared somewhere else, I am referencing which other docket that document appears or that text message appears. So I'm saying if this message appeared in docket number 1, well, Friedman also used it in docket number 84. He also used it in docket number 963. And so all the instances where they are. And sometimes the fact that they used it in different dockets, and this is why I think other timelines are not the same as mine, is because I actually concluded it turned out to be a whole different day, because this one is done in GMT minus 4 hours. And that makes it the day before, not the day that you think it happened.
Oh, okay. So it'll be an actual minute by minute, like live timeline kind of.
Well, I'm making everything Pacific Standard Time.
Yeah.
Because if I go off of whatever time it happened, like let's say they were in California or I don't know that. All I can do is try to get everyone on the same timeline so that you know how things happen. So did they happen on Pacific time? No, but I will reference in there like the time that it is, like GMT minus 4, GMT minus 5, GMT minus 6. And then I will say this is the PST or PDT time, right? Is it in daylight savings or not? And I put it all in order. So that's the only thing that I think makes this timeline different than the timelines that are out there, is that I'm actually synchronizing them all under one timeline. So
that is
kind of geeked
out.
That
is insane. Liner Friedman, if anybody from Liner Friedman is watching, I'm sure Carol would love to work for you.
So someone pay me.
Jed,
I'm actually losing time from my other job.
Jed, if you're watching, we know you're watching.
Jed, I have my own team.
Yeah, I'm on Jed's Hawaii team, so unfortunately I'm too busy to help with the timeline.
Yeah, so I'm kind of geeking out about it, but that's what it is. And I think there will be probably like and this is the other cool part about the timeline. If there are screenshots that are not produced, so like for example spoliation, and that's what I'm saying, I looked at Lively's evidence on spoliation. It's just not what she thinks it is. I looked at the screenshots, saw if they were messages that I had through other means, or if they weren't, then I go ahead and put them on the timeline. They're not, some of these conversations, I'm like, why am I transcribing this? This is so dumb. Like, this is them talking about their family. This is them talking about
something it's not.
Something silly. This is but any screenshot conversations. Also, Sarah helped me actually translate a very blurry email.
Oh yeah, I forgot about that.
Yeah, so a very blurry email that right now I haven't come across anywhere else except a screenshot. And then I go ahead, and if I can see the time, I go ahead and squeeze it on there. Now I don't think I got into the issue that I'm running into. There are some documents that do not say the time zone. There's some documents that are clarified through other dockets what time zone they are. So I can clean that up and fix it and rearrange where they go. But some I put like, I don't know the time zone. It just says 12 p.m. I don't know if it's New York time or this. But I do put that in there so that people know, like, we don't know this. And there's some screenshots and some stuff that both parties have shared that no one has given us the date on. And so usually like I try to read the memorandum of law or something to see if they reference it there. And if they reference it there, then I at least put the date and I put no time shown. So I don't know.
But we don't know like when exactly.
Yes. And then some don't have that at all. So I'm going to, at the end, go through other dockets and see if I can find like other cues of when it could have happened. And I will include those somehow. I just haven't thought of an idea of how, because they are relevant. I mean, they're in the docket for a reason. But yeah, so those are the two main issues I'm running into. So
If you find something that doesn't fit anywhere, send it to me.
okay,
Like
yeah,
if you don't have a date and time, it might be easier for somebody who's not familiar with the whole timeline to kind of think where it would go.
Yeah, I have 25 items that I don't know where they fall. Well, some of those, so again, some of those are repeated things because I do save everything so that I can reference in what dockets they appear.
Okay, so some of them might be duplicates.
It may not be 25. It may be like 10, like 7, and they're just repeated so often in other dockets that I save it just so I have it. But I don't have a system for them. So, but there's a handful.
Yeah, if there's anything you just like don't know, send it to me because that's something I'm kind of good at is trying to figure out like,
ooh, okay,
what this yeah, where this goes.
Okay, yeah, I'll send that over. So it is going to be kind of interesting, and like I said, I guess I just want to make sure that the information is out there. There's a lot of people in the comment section who needs it. There's a lot of people in the comment section saying like, "Oh, but Lively did this and Lively did that," and I'm like, if you knew that Lively had agreed to this here, and you knew that this conversation happened here, you wouldn't be arguing that. So this timeline is very much needed. It is very much relevant to this. So, guys, no, I really haven't included anyone on it. I've just plucked away, and I was slow before. My husband gave me some tools, so now I can move a lot faster. So hopefully, I don't know.
What does your husband think about all this? He's seen it from the beginning.
He loves me to have hobbies. He loves to support me in anything I do. So he's just like, oh, I love this.
He supports your mommy sleuthing.
Yeah. But yeah, it's just so that's why I'm like, it is important. Like, for example, like a lot of my comments on the NYT article were like, oh, Lively felt, like she was SH by the birthing scene. And then I was like, well, did you know that Lively signed her nudity rider May 18th? That scene didn't even happen till this date. So she knew. Okay. So she knew that. So she knew, and she was allowed to show her legs. But now her attorney wants to claim her legs were naked. And it's like, girl, your contract.
It's in the contract. Yeah.
It's in the contract. So hopefully this timeline will give you guys all the tools to argue with people in the comment section. That's what I want. What is this?
Damn, Carol, this undertaking has me picturing Charlie's conspiracy theory map from It's Always Sunny.
Okay, the way his face is how I feel like I'm like the energy that I'm giving out, like yeah.
That's why it's so funny to think of that website thing. Yeah. I just remember that because we're like, well, and I think we even said at some point, like, what if, like, are people gonna want to see it? Like, are people gonna care? Like,
and I was like, I only have 5 pages on there.
Right? Like, it's just a baby website. Probably nobody's gonna look at it.
Guys, I had like 1 viewer. It was probably Sarah.
It was probably me.
It was probably Sarah for like, I don't know, 2 months.
And then I sent it to Chris because he was talking about the smear campaign websites. So I sent it to Chris and I pretended that I just found it. And I was like, hey, I found this website. Do you think it's part of the smear campaign? And he was like, that's really weird because, like, no, there's no SEO. There's no backlinks. It's like, I don't think so.
I haven't even had time to go through because I do want to go through the SEO. I do want to improve it. I do. And then, like, I've gotten feedback like, oh, why don't you put the full names? There was a reason why I did it the way that I did it.
Yeah.
And I will eventually do that. I just think, like, I need to get this big thing out first. Then I'll figure out. Like, I'll do the hearing page and I need to update the attorney's page. I need to do a few tweaks to it. But I think you guys will really appreciate the timeline and hopefully it gives you the tools to argue with people in the comment section. So
Jed got his appeal. That's why I'm in Hawaii right now celebrating that he got his appeal.
Sarah, you're so funny.
Questions. Yeah, I was trolling Chris. I said, do you think this is part of the smear campaign? And he's like, that's really weird. I don't think so. He's like, it looks like though someone just made a website. I was like, yeah, that's so weird.
Jed's Hawaii team, stop.
So of course we're in Hawaii. We're celebrating that Jed got his appeal. So it sounds like he got an extension to May, or it's because there's a date of April 18th or April 15th, and then there's another date of May 15th. So this is going to be in court for forever because appeals can take a year. So this is not going to be over, and because it's a defamation lawsuit, it's like it's an appellate court. Like I had a motion to dismiss that this lawyer I work for was waiting on for a year and a half.
Oh my gosh.
Like
someone said put that on a shirt.
Sure. Jed's Hawaii team. I did make merch. I got a thing for merch. So I bought a t-shirt. But maybe I should make one that says like Hawaii. I don't think I'd make like Jed's Hawaii team. I think I would just say like Hawaii and maybe have like a I don't know.
Or at least Hawaii team. That would be funny.
Hawaii team.
That's hilarious.
He does not have a team in Hawaii. I need to put up my allegedly.
Allegedly.
Yeah, Blake, please don't use this as evidence. This is a desktop wallpaper from Hawaii. This is not really Hawaii. Imagine that on a shirt.
What is it? Give me
that Babcock. Where did I get my? Let's see. I'm gonna show you this shirt that I made because I got a thing and they were like, they're like, we'll send you like a cheap
like a
sample.
Like a sample.
Yeah, let me see if I can. Let's see, where is it? Let's see if I can. Let's see. How do I do this? Oh, that's why. I'm trying to.
Is there anything, someone asked, is there anything you find super interesting from the timeline? I have a theory from what I've come up with the timeline so far. I believe that Stephanie Jones is the one that sent the content creators that Blake Lively is going to come out as a victim. I think she did Insta accounts and that she sent it.
That is interesting.
Because the dates align. So the dates align, and also a huge clue is the conversations of Blake that around that time weren't that she was a victim. She felt very victorious in her marketing. She felt very victorious in everything. So she did not believe she was a victim. So I think, and there was something that Stephanie Jones said in her deposition, that she said about content creators, and I found it very odd. And that's kind of, I was already seeing the pattern, and then I was like, ooh, that is my new theory. I think Stephanie Jones created those Finsta accounts, and she's the one that reached out, and she's the one that created that mess.
That would be crazy, because I'm also curious if Blake ever hired Stephanie Jones. I'd love to know if she ever actually. Here's the shirt.
Oh, I like it.
That was all I had for a merch idea. I heart case law. And I like that color purple. So, but maybe I should do the Hawaii team.
It's regal. It's
regal. I'm trying to give elevated and let's see.
I do like it.
But maybe I'll have to do a Hawaii team one.
Hawaii team, allegedly.
Allegedly.
Yes. Okay. So someone said Stephanie Jones was subpoenaing content creators at the same time for the website against her.
Maybe she gave her the idea.
She surprisingly was in tune with a lot of things happening on social media. So I think it was her that sent those messages, especially based on how Leslie Sloan was acting at the time. She wasn't doing, I don't think it was, at least. She was very much still aligned with Melissa right after those messages came out. And so that's my new theory. I haven't really shared that anywhere, but I because I want to finish the timeline before I show you guys that. But that's my new theory. I think Stephanie Jones is the one that knew and sent that allegedly.
Allegedly, right?
Yeah. I think my next website's going to be Stephanie Jones breaches contracts.com.
I would definitely get a t-shirt that says Stephanie Jones, and then it just has a picture of a Birkin.
Oh, okay.
Were you there for the Birkin thing? Do you know what the Birkin thing is?
No.
Okay.
What
somebody on Reddit, this is super clever. So somebody on Reddit thought that there was bots on some of these It Ends With Us lawsuits Reddit. So she thought, okay, well, who would hire bots? So she started posting things like Justin Baldoni did this evil thing, or he did this bad thing. Didn't see any bot activity around those comments. Then she started saying, Blake Lively does this. Blake Lively has, bad behavior. She cheated, whatever. Didn't get much bot activity. And then she started saying, Stephanie Jones steals Birkins. She goes to department stores and she shoplifts Birkins. And immediately she was getting anonymous Reddit accounts that were arguing with her on different threads at the same time, like bot activity.
That's
so
hilarious.
She thinks that Stephanie Jones has hired bot accounts to infiltrate, but she was saying things like Stephanie Jones I heard that she goes to stores and she goes and she shoplifts Birkins and you can't take her anywhere because she shoplifts. And of course, like, regular people aren't interacting with these comments because they're like, I don't even know what this
person looks, yeah.
Right. But every time she said that, she'd get a bunch of responses from the same group of accounts. So
oh, did she leave? Sarah? Did you put yourself in the... Guys, I have to wait for Sarah to jump back in.
I kicked myself out. I'm sorry.
Oh, I was like, did you kick yourself out? Oh, Stephanie, that's interesting.
Stephanie Jones came for me.
She was like, internet down. That's so interesting. Yeah, she seems to know a lot more about social media and more in tune with that than anyone else. So that kind of tracks. And then also, I've noticed that if you're arguing with bots, if you use sarcasm, they think that that's you agreeing with them, so they stop.
Yeah, and somebody else was showing comments as like a better example of the bot thing, where they were saying things like, did you see in Justin Baldoni's deposition where he said he has a foot fetish and he was licking people's feet and he wanted to lick Gottlieb's feet? And like, then there were these comments that were like, oh my God, I can't believe he did that. And it was so disconnected from what the person actually said that they're like, this is what it looks like when it's a bot account.
Yeah.
Because it was so, yeah. I'm trying to find the Birkin. There's a subreddit called Stephanie Jones Shoplifts.
.com. No, I'm just kidding.
Okay.
Allegedly.
I just, let's see. Let me see if I can see.
At that point, they're just trolling Stephanie Jones, but.
Let's see. Yeah, I don't see where. Yeah, Aaron Perez, that Redditor. Have you heard this account?
No,
I think I've seen this account. Aaron Perez is like a prolific kind of Redditor that has covered a lot of this case. And basically I think he was the guy that said Stephanie Jones shoplifts Birkins.
That's hilarious. I haven't been on Reddit. I need to.
Some of it, yeah. Some of it's.
Honestly, I get hand slapped so much that I'm like, I don't know that I'm doing something wrong. Like one time they said I was being too sarcastic. And that it seems they were like, hey, can you not be so snipey? I think they said, or like sarcastic, snarky. And then I was like, oh, I wasn't like, that's literally my opinion.
Yeah.
Okay, I'll try. I was like, oh yeah, I didn't mean to, but okay.
I'm sure. Yeah.
And then one time it was like, yeah, that's the community rules. And then I was like, okay. And then one time I posted like, hey guys, I posted the deposition there, like before it was out other places. So I shared it and they were like, you're not supposed to share your website. And I was like, oh, I'm sorry. I didn't know. I was like,
Yeah.
I guess if I have to do more, I probably wouldn't. I would just say, hey guys, the deposition is up or something. And then they were like, well, we know you're not promoting. And he's like, but you're not supposed to do that. And I was like, okay. So then in another Reddit subreddit, they were like, you can post your website. And I was like, oh gosh, I can't keep up with the rules.
Right. Like what I've never posted since there. I had a Reddit account back in like 2007 and then I haven't since then.
It's
and
really
who could play Stephanie Jones in the movie, Nicole Kidman or Kate Hudson? The answer is Reese Witherspoon.
No, Nicole, because Nicole has this like air about her that she's always frustrated. In all her acting. It's always like, you know.
I could see that. I still want Ryan Murphy to make a movie or a show about this. I want him to play James Vituska. Have you seen Ryan Murphy and James Vituska?
No.
Okay. You have. This is the resemblance is uncanny. All right.
Stop.
Ryan Murphy.
They literally look the same.
Okay. So we're going to share this. Let's see. This is what Ryan Murphy looks like. Just to give everybody.
Especially that glasses one.
James Vituska. This is what James Vituska looks like. It's probably the best picture of him. And then just to go back. Murphy. That's Ryan Murphy. So I want him to play James Vituska. I want James Vituska to be the narrator. And I know people are going to say, well, he's not a reliable narrator. That's exactly why it would work. He would tell you everything that's going on. And he would just be like...
kind of like that Elvis movie where the guy that you distrust the most is telling the story.
Yeah. And you're just like, I think you're full of shit.
Yeah.
But
I think
also
by the end of the movie.
Yeah. And then it's also like, I think you're full of shit, but you're also somehow the most reliable person here. Because you're the only person whose story hasn't really changed. It just
we'll see about that.
We'll see if his story changes, I guess. That's true. So I did want to ask, what did you think of Ryan Reynolds not being at the settlement conference?
I didn't think much of it, to be honest. I try not to think about Ryan Reynolds at all. I just thought, like, you know what? I guess if he didn't, like, okay, in all realness, I think if he didn't go, maybe they want to, I don't know. I thought, I'm trying to think back to what I originally thought and, like, how that kind of changed. I thought just, like, they're going to say that he was out of town doing work or something, and that's why he's not there. You know, I didn't think much of it, to be honest. I was just like, it could go either way. You could make an argument both ways, right? Like, oh, he's not there because he doesn't want to make a public support statement. Like, we still haven't seen one. But also, if he does go, then it does seem like a power play. But either way, I think it's like he doesn't want to make his public statement. I really think it comes down to the PR. I think he's trying to keep his options open. Like, where does he go from here? How does he change his look? He's a brand too. And he also has to respond to Disney and respond to all those people. And he has to avoid his litigious wife, you know?
I mean, I do think it was kind of a PR move because I do think they had to get him on the phone. Because I can see where the settlement negotiations would say Ryan needs to sign an NDA. We have no settlement discussion without Ryan signing an NDA. So I would feel like they would have to have him available. So I was a little surprised.
Point, I don't think NDAs are even trustworthy. I think at this point it would be like, you cannot run any PR stuff. Like, It has to be something like that, because I'm like, look at Stephanie Jones. She didn't care about an NDA. People don't care about an NDA. NDAs expire. Like, it has to be bigger than
Like,
that. I don't know.
never say anything. But I also kind of
Allegedly.
think, I do think it's like he's distancing himself, and I'm like, I don't know. It just kind of feels like,
Well, he knew Hugh Jackman wasn't going to be there, so
maybe he wanted to dress as Deadpool, but then they wouldn't let him, so he stayed home.
And red and green would have been complimentary.
What is red? Violence and courage.
Violence. What did you think overall? Good, bad, indifferent?
I agree. I don't think settlement's ever really been an option. I don't see why Wayfair would settle. I think they'd rather this go to trial. There's a chance everything gets dismissed. It's kind of weird that, like, looking at the causes of action, I'm like, there's a chance everything could get dismissed. And I don't know how Lyman's going to feel about that. But if you look at the McSweeney case, she had 24 causes of action, and I think he dismissed like 21 of them.
20?
Yeah, because she had like a lot of different employment for like New York State and federal and like all these different kind of duplicate causes of action, and he dismissed like 21. So he has no objection to gutting someone's case.
Somebody brought out a good point. I think spouses have to be involved because in settlement due to shared assets.
Yeah, I mean, that's the thing. And he's paying the legal fees. If her salary is $3 million, she can't afford these fees. So he's on the phone. That's the thing. He is at the settlement conference. They're on the phone with him. It's just he didn't show up physically. I guess the optics are that she's facing the big evil guys alone.
I think she should have been there with him. I think that would have been a stronger message.
I guess his suit was there.
The comments. Yeah, we can all spot the PR tactics a mile away.
Yeah.
I am right now. My goal is to, in every Margot Robbie post, to say, "Oh, Blake Lively could never," or just to say like, "Oh, Margot Robbie, this would have gotten you a federal case," because like she's like, "Oh, I improv running into Jacob Elordi's arms, and then I ended up kissing him." And it just ended up being such a beautiful scene that we ended up putting it in the final cut. It wasn't scripted. We didn't talk about it, but it ended up being amazing. And I was like, yeah, you would be in federal court right now. Like, if Blake Lively wins, you'll be in federal court. And that would be SH. Because Jacob Elordi didn't give you consent to do that. If his contract is not valid,
right,
and his agreement to be in this creative process is not valid, and his nudity rider is invalid, then what you just did was assaulted him.
Blake could never. Wuthering Heights. To be fair, I'm not sure Margot Robbie Wuthering Heights. I haven't seen a lot of positive about that, but I'm curious about this. Without a crystal ball, gut source rumors Stephanie Jones and her husband got a threat from Ryan. It is his idea about the stolen messages.
To get the stolen messages from her?
I mean, she would have had to tell them that it existed.
Yeah. I think maybe it's his idea to get the Van Zandt stuff.
But it would, yeah.
It would have been his idea to do that.
Jacob,
I don't think they care. What?
Jacob Elordi deserves an Oscar for shirtless running around on the farm.
Oh, that's really funny. But anyways, that's what I'm saying. Also, my other big comment contribution is don't put Brandon Sklenar as Batman, and that's making some people upset. So if you guys see my comments, please support me, please.
Do people want him to be Batman? He doesn't seem that interesting.
He seems so mid to be Batman.
Yeah, he's not a bad looking guy, but that's about all I can say.
Yeah.
See. Yeah, so I do want to clarify because BB Well actually said spouse wasn't necessary to be there. He's not necessary to be there. But practically speaking, I would imagine that he can be in some of the NDA things. So I feel like he was available by phone, it's common for people to be like, hey, I got to check with the spouse because this is going to involve them, you know, or I need to ask them about this.
I also will say, like, you know, someone put Blake Lively's going to lose, so no one to be shocked. I actually think, like, look, if for some reason Judge Lyman just likes the other team so bad, he's going to, you know, find a way. Or also maybe just thinking, like, I don't want to get overturned, or I don't want to get this. If he allows it to go forward, like, for whatever reason, obviously for legal reasons, right? For legal reasons, he allows it to go forward. Like, I just think it's gonna be an uphill battle for the Lively team, especially in getting 12 jurors to be unreasonable and take this unreasonable stance with her. I think maybe she'll find a couple, but not all. So eventually, what are you?
I'm sorry, I'm just picturing Judge Lyman issuing like a 1-paragraph thing that just says like, "Fuck it, we ball." like let's just go.
We ball.
Like, just fuck it, let's go to court.
Yeah,
democracy is crumbling. I want to see what happens.
Because I'm like, if he just says like, I can't do that, you know, like these people are so litigious. I truly think Baldoni will be dismissed. I'm excited to see what PR happens when that happens. Like, ooh, that's going to be crazy. But I mean, mine is a huge speculation. Imagine him talking in so much slang.
There's just a voice memo to the court, just saying, just him dictating to his clerk. You know what? Let's fucking go for it. Let's just do it. I was talking to Doug, and he's like, "It's about time we fix something in Hollywood. Let's just do it."
And it could be. I'm like, I you know, people saying like, "Oh, he's not going to do that." I'm like, he's a federal court judge.
He can do what he wants. I mean, he can do what he wants.
Yeah, I was like,
let's see. The Van Zandt suit was filed 2 days after the last check for box office bonuses was issued. Thanks for the money. And now I'm gonna cancel you because that will uncancel me, because that's how that works.
Mm-hmm. Oh, I'm gonna have to put that in the timeline. I haven't got into there, so I'm in the dockets 900s right now, 960s. But when I get there, guys, I will. Well, we're at the 3-hour mark, Sarah. I'm not sure if you want to wrap it up.
I'm losing all my brain cells.
Yeah, we're kind of getting into, we're just cracking up territory.
This could get to the more interesting part of the live. Ryan's suit was there. She did miss my joke earlier, so I'm going to repeat it, which is, I think that Blake Lively brought her mahjong to court so that she could practice winning, since she's not going to get a chance.
That's a good one. That's a good one.
Yes.
Ryan's suit was there.
It wasn't even his suit. It was like a tribute. But I did buy a dupe of her purse, so you know what? I was influenced. There it is.
You like green a lot, though. That is,
I do.
I think that's one of your like top colors.
That's my power color. So, yeah. And I don't like her actual purse, like, because the actual color in different light is like kind of dark. I just like this kind of light green that it was, and I was like, I'll find.
But tell them when you're gonna open it.
I'm gonna open it after I do all of my Sony videos. I am deep into the lore of Sony.
Okay, so I'm not yet there in the document, like unraveling, but if I come up across something interesting there, I'll definitely.
Yes.
You know.
I'm going to do a timeline of Sony, and it's insane. It's, so there's, this is a preview of what I'm going to do. I have a live called The Sony of It All, which is where I went through every single thing that Sony wanted redacted.
I didn't see that. I don't know. I have to put it in my ad.
I think, do I still have it up? I think I still have it up. It's called, it's called The Sony of It All. It's from 3 weeks ago. And this is probably the best, like, it's a live, it's like an hour, but it is probably the best. It's like every single thing that Sony wanted redacted or removed, and what I think it is, because they didn't say specifically what they wanted. So I just have to guess from what got unredacted. So
Oh, okay.
yeah, so this is putting like how much did she piss Sony off? But then I'm going to go into the giant, this is my pitch. The giant problem that Blake Lively has with introducing Sony in her Darvo experts report.
Wait, so how many episodes is it?
I don't know. At least I'm gonna start with one, because the Sony of it all is like part one. So I'll just leave that one up. But then the second is gonna be like what I think Wayfarer can do, because there's this thing called the empty chair defense, which is basically where you say it's not our fault, it's this person's fault, and they're not here to defend themselves. So they can pawn this all off on Sony now. They can basically blame Ange Giannetti for a bunch of things, and Lively has an expert report. If she doesn't put her Darvo expert up, they can bring the Darvo expert in. Like they can call her as their expert, and they can use her report where she's blaming Sony and Ange for all of this stuff. And they can try and use that. So,
guys, so if you guys haven't followed Sarah yet, there's a conversation that she started, and she's like, I gotta go run with this idea. And so
yeah,
she doesn't know how many parts, but go watch part number 1 if you're not following her already. Give her a follow.
It's called The Sony of It All.
The Sony of It All. Well, you know what? I'm gonna link it to the description, and I would suggest you do too.
Yeah, I'll do that thing you showed me where you can like link a video somehow.
Yeah, as the next to watch.
Yeah.
But hey guys, I gotta run.
It's 10.
Yeah.
But this was fun.
This was fun. We haven't done this in a while.
It reminds me of the TikTok days.
Yes. Yes, it does. The good old days.
And do the YouTubey things.
YouTubey things. Like
subscribe.
Thank you so much, guys, for even watching it.
Yes, if you've been here for the 3 hours, we are no bocce, but we try.
Read the article to you all.
Yes, there we go. Yeah. So, and we miss bocce.
Yeah, we'll have to plan another video on this. Maybe on my theory about Stephanie Jones. We'll see.
Yeah, Stephanie Jones steals Birkins.com.
Stephanie Jones breaches contracts.com.
Stephanie Jones steals texts.com.
Ooh, that's a good one.
And then it's just all Van Zandt.
Oh, that's a good one. I'm just gonna link it to the Van Zandt court case. Try defamation there, Stephanie. Ha!
I like that. I like this. So
I like that. No, it's a good idea. But thank you, everyone. Appreciate it. Thanks for watching us.
Yes, and thanks for joining, and have a good night, everyone.
And another one. All right, Sarah. Have fun. Thank you.
Yeah, thanks for joining. Bye.
Okay, bye.